I know. I'd like to welcome you to the 1 o'clock regular session. Would you please stand for the Pledge of Allegiance? And Mr. Gale, would you lead us in the pledge?
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Taylor, are there any actions to report in closed session?
No, Madam President.
Okay. Could I have approval of the agenda and order of agenda items? For the record, on page 6, on the minutes, paragraph, let me see here. Third paragraph from the bottom, it should read that legal counsel announced that due to the large volume of attachments, copies were not included with the agenda. However, he brought one complete copy to the meeting for public review. He mentioned that over 90% of the documents could be obtained from the California Energy Commission. Just wanted to make sure that the public understood we did have one copy here, and that's would go into the minutes. Other than that,
Move for approval of the agenda.
I'll second.
okay, please vote. Okay. This is the time for public comment. If you would like to speak to the board, please come forward, state your name for the record, and please limit your comments to no more than 5 minutes.
Mike Morgan from Brawley, and this morning something happened that caused me to come here with some paperwork that I've promised you before. I was out at the Salton Sea, and as the big white clouds of dust rose off of it across the farmland, I tracked them all the way to the city of Calipatch. And there I decided to go in and get a soda, and when I went in, I met one of your ex-employees. He said, Mr. Morgan, he says, you're always on that TV and you're telling these directors about things their lawyers are saying. Why don't you give them the paperwork that shows what's happening to Imperial Valley? And meanwhile, Calipatch's full of white dust. So I did it. It's to my ability for 1 hour. April 07, David Osias, to Craig Morgan's comments question about the Salton Sea. The only thing the transfer did is it created a funding mechanism for the Salton Sea, which is not nearly enough to solve it. It's just seed money. In a cause the law to be passed, it said the IID will not have to contribute any more ever, period. That is totally against what you'll find in your trial statements in Candy's court. So totally against. The next 2 years later, 1 year later, Ellen Spellman came and gave you a workshop here. And in that workshop, she told you that you had the liability, the landowner, the IID had the liability from minus 228 to 235, no other agency. And I told you that that was hard to hear in her presentation, but if you get the printed copy of it, which I'd be happy to give to anybody, it says, quite frankly, you are fully liable for it. But then she also says, after the $133 million, the state takes all the risk of any excess spending. That $133 million was Coachella and San Diego and your contributions. Again, your attorney into trial said no, there was never a promise of the state to take on any excess restoration funding. Then Jeff Garber, in his presentation, August 26, 2008, if you remember, he went through a thing about whether the QSA, the contract was more important than the promise, and that the contract from the state would absolutely bind them to restore the Salton Sea. He says, IID's contribution is severely backloaded, which meant you didn't have to put up your first money. All the money comes from the transfer, so that your $45 million or whatever comes from the transfer. And then he says, and this agreement says the state agrees that it is solely responsible for the environmental mitigation costs and the restoration costs above these amounts. Your general counsel. That's not what's said by David Osias in the trial court in Candy in 1109, which is this thing. So if any one of you people, and I would represent Stella, Anthony, and John Pierre, need to do the most homework, I would be happy to leave you it or leave it with the newspaper. You're getting misled. So I hope you listen real strongly today about a second opinion, because the QSA that you are upholding an appeal on could kill this valley. And your lawyers have not told you the truth on what your liabilities are. So if you'd like it, I'll give it to you. If you don't want it, I'll give it to the
I would be
press.
interested in reading that. If you
Give
could
it-
give
give
them
it
to
to-
Ms.
give it to
Rivera, and
Gloria.
she'll make copies for the board.
Put the Gloria, please.
Thank you, Mr. Morgan. Anyone else would like to approach the board at this time under public comment?
Do you have someone that can put a display? Something
Pardon me?
Do you have someone that can display something from a CD?
Yeah.
We do, but is it more than 5 minutes?
No, no, no.
'Cause you have
It's-
5 minutes.
It's a map.
All right.
Good afternoon. My name is Michael Cox. I live in 249 Andretta Place in Brawley. I come before you today. Good afternoon, Madam President,
Good
board
afternoon,
members,
Mr. Cox.
Mr. Kelly, Mr. Taylor, and staff. I come to you today with some comments and questions about a group of solar projects that are proposed northeast of Brawley, east of Calipatria. Specifically, our family's property is involved in what they call the Mayflower Solar Project. These were gone before the Environmental Evaluation Committee, subcommittee of the Planning Department last week. There were 4 projects totaling about 2,000 acres, and I believe all the acreage is Western Farms trust lands that the district may be in process of selling to Solar Gen 2. One of the questions is, and this is a map that shows the layout of the Mayflower project. Near the east side is Highway 115. About a half mile south of the highlighted area is Rutherford Road. Maybe a mile to the southwest is Weast Lake. And this site shows there's 2 quarter sections or 160-acre parcels on the east. And then there's another quarter section and a half. That's about 240 acres in that rectangle on the lower left. First question I have is that back, I believe it was August 9th, this board approved a service interconnection agreement, and it was with Greenlight Energy Corporation for 150 megawatts. And as far as I can understand, that is the same 150 megawatts to come off of this acreage. But the power purchase agreement with San Diego Gas and Electric is with what they call Solar Gen 2 LLC, and that's the group that put these cluster of 4 projects before the planning department. So my question to you is what is the distinction between Solar Gen 2, which I believe you have is in process, maybe, are they in the process of buying that property from the Western Trust Lands, or is that confidential?
It's been our practice that if you have any questions, put them in writing, and then we will get back
All
to
right.
you with the answers.
I'll talk in generics then. First point is that our feeling is that a solar project of this is really incompatible with intensive agricultural usage. SDG&E in their literature has described these projects as going on fallowed farm ground. I believe the IID has been leasing these lands pretty much ever since you acquired them. It's not what you would call classic vegetable ground. It's heavier ground, but it has been farmed in forage crops, Bermuda, alfalfa, wheat. Some of the ground has Sudan, some other crops on there. It's been farmed by, part of these parcels have been farmed by Charlie Slater. One of the other projects have been farmed by Pat Dockstader, among others. If you look around the perimeter of those highlighted areas, there are 19 fields that either touch or are within 1/4 mile of those highlighted green areas. And the lower right-hand one is a full quarter section, and so that's over 1,500, almost 1,600 acres that's impacted within 1/4 mile of this solar project, which means any time that we want to apply pesticides, we're going to have to notify or make sure that there's no people within the area of the solar project. There are county roads that go up through the middle of this. Jackson Road goes through the middle of it. Williams and is on the north side. Pickett Road goes through the middle of it. We have concerns about every time we're going to be doing field activities. The dust is going to impact their panels. We have a concern about, it's under the conditional use permit, it's not considered a zone change. It's just a temporary usage of this land for this solar project. Many of us feel that this land will not go back into ag production if the solar project is terminated at 25 years, and the permit is for a 25-year period. Ground like this, when it's not being farmed, doesn't have irrigation water going through it. Salty water will percolate up through it. You'll have compaction as that ground dries and shrinks. We're concerned about the weeds that might grow around the perimeter. I know that I believe the lease provisions you had with them talked about certain constraints on what they had to do about making sure that it returned to ag production. This is 2,000 acres, and as I understand it, there are other parcels that have been applied for solar production on active farm ground, not on ground that's near the edge of our water service area. And I think one figure I saw was there's up to 14,000 to 15,000 more acres, or total acreage, maybe including this 2,000. That would have a sizable impact. They tout that there's going to be 300 jobs in the construction phase. That's only the first year. Mr. Carey, in his presentation at the hearing the other day, said there will be no full-time, or no employees on site. It's going to be remotely monitored. The only people they're going to have out there are those that come in to wash the panels, routine maintenance, dust control, weed control. 25-year period, 2,000 acres. I think Lindsay's figure was 0.1 jobs per acre, so that's 200 jobs. 300 jobs in a short-term construction period, to me, doesn't equal the potential loss of jobs from removing 2,000 acres of farmland from agricultural production. Even if you only look at 25 years, and I would contend that this is going to be out of production more than 25 years. So I would hope before this board approves any further power interconnection agreements on solar projects fully within and surrounded by farm ground, that you take a good hard look at the fiscal impacts. I think you've made comments about not wanting to fallow ground, and to me this is fallowing ground. And when you said the ground had to be fallowed, there had to be some mitigation for those third-party impacts. I don't see mitigation for third-party impacts here. You're going to receive wheeling charges. You're going to receive what I understand is a sizable dollar per acre for sale of this to pay down the Western Farmlands debt.
And when you say you mean the Imperial Irrigation District, not myself personally.
Yes, ma'am. I'm sorry.
Make that clarification, please.
The IID.
Thank you.
The IID. I don't know what kind of side deals you've made.
Excuse me, I didn't hear that. What did you say?
I don't know what kind of side deals have been made. What I have heard is that
you
there
know,
was 375,000.
My last name isn't Cox, so I wouldn't.
Our family is very grateful for that.
Well, hey, mine is doubly grateful for that.
Stella,
Mr. Cox, your 5 minutes are up. Thank you.
Could I have one more minute, please?
It's 5 minutes for everybody.
All
Someone
right.
else can come and speak.
Thank you. I urge the board, please
Thank you.
reconsider these.
Thank you. Anyone else? If not, we will now, well then, please come up to the mic. Gloria, can you time it and then let me know when the... Okay. All right.
My name is Carolyn Allen. I live in Brawley, California. And I'm here to complain about the solar projects that are planned for farm ground. I feel it's an incredibly bad decision to try to take productive farm ground out of the production. That they should, you're just looking at this one project, the Solar Gen 2 project, and the impact that it will have, as my brother described. But we need to look at it in a cumulative effect. It is not just this one project. There are many, many solar projects planned throughout this valley. I have heard of figures up to 22,000 acres possible, maybe even more. This will have a huge cumulative effect on the loss of jobs that are going on, the loss of agricultural crops that are a good tax basis for this county. I know that in the Farmland Protection Act, it says the nation's farmland is a unique natural resource and provides food and fiber necessary for the continued welfare of the people of the United States. Each year, a large amount of the nation's farmland is irrevocably converted from actual or potential agricultural use to non-ag use, which this definitely is a non-ag use, even though you're using a conditional use permit and not rezoning it out of agriculture. Continued decrease in the nation's farmland base may threaten the ability of the U.S. to produce food and fiber in sufficient quantities to meet domestic needs and the demands of our export markets. Being not able to meet our own domestic needs, I feel, is a security issue for this country. The extensive use of farmland for non-agricultural purposes undermines the economic base of many rural areas, which is what Mike had talked about. You know, ag is the center of our economy down here. So many people will have a domino effect. It won't just be the farmers, but it'll be the farm workers, it'll be the seed companies, it will be the chemical companies, it will be the harvesting companies and the office support staff and the field laborers. It says federal actions in many cases result in the conversion of farmland to non-agriculture uses where alternative actions would be preferred. There are alternatives to putting solar units on farm ground. You see many times where they are up on the rooftops of houses, on office buildings. There is no need to take productive farmland out of use. Also, that you are claiming that the farm ground is only being converted temporarily, with the word temporary in parentheses. I have a letter from, it's Meraz Meredith, M-E-R-A-Z, M-E-R-I-D-I-T-H. And in it, she is addressing the point that says, you commented in an early email to my colleague that you were looking for a letter from the Department of Conservation that states that the conversion of farmland to industrial solar use for 30 or 40 years is considered temporary and reversible. They found the letter, and it says solar projects are generally considered to be temporary. The use of the quotation marks is meant to call out the ironic use of the word temporary, as used in the NOP. There are also other uses of the word. However, that was the way in which the project was described in the NOP and the DEIR, and that's why it was repeated throughout the response letter. We will review our letters in the future to make sure that this misinterpretation does not happen again. Thank you for bringing it to our attention. The division has never considered a 10 to 40-year lease on ag land to be temporary, although the terminology is often used by solar companies to lessen the idea of long-term impacts. In addition, in March 2011, we released the division's official policy on solar facilities. We consider them an industrial use and a significant impact to agricultural resources.
Mrs. Allen, you have one more minute.
The likelihood of restoring the land to its previous agricultural use will be dependent upon the solar facility market and demand for energy. This is a very large unknown factor, and therefore projects of this nature may not be as temporary as they are thought out to be. And there has just been, the use of temporary, I think, was a ploy to get this project just pushed through as fast as it could be. I also have a letter from the Department of Conservation, and it says that, however, the entire purpose of going through the initial study for the NOP is stated that because solar generation facilities are on allowed use within the zone district and subject to conditional use permit, they do not conflict with existing zoning for agriculture, and thus no pact is identified. However, the entire purpose of going through the conditional use permit process is to trigger a thorough CEQA review of the project's potential impacts. The development of 903 acres, which they're talking about the project
Allen,
at
your
Pullman
5
Road
minutes.
and Anza
Your
Road.
5 minutes are up. Thank you.
The development of 903
Allen, your
acres
5 minutes
of
are up.
prime farmland. You develop prime farmland and farmland as statewide
you.
important is a substantial amount of development and
Mrs. Allen, your
displacement
5
to
minutes are up.
agricultural
Thank you.
resources.
Thank you for your comments. Anyone else?
Good afternoon. My name is Brett Levitt. I live in Brawley, California. My husband started Levitt Ag, which is an entomology business, and he also started Arrowhead Applicating, an applicating company. I'd like to talk to you guys today about the solar project that you're considering, and I ask you to reconsider it and shut it down. I do not feel that it is conducive to the valley. I see agriculture as a very strong and important part of the valley, and I see it as the future of the valley. And with the solar project and all the geothermals popping up everywhere, I feel like people are seeing that's the future of the valley, and I take offense to that. I think agriculture should be the future, should be the past of the valley and the future. I have 3 sons, and I would love to see them take over family businesses to be able to get summer jobs driving tractor. And as long as projects like this keep coming up, that's not going to happen. You're going to drive people out of this valley because there's going to be no more work. The amount of jobs that the solar company is going to create is not going to cover the amount of jobs lost when you take land out of ag production. There's supposedly 1 job per every 9 acres of ag land, and the solar company is not going to make up for that. You have to think of chemical companies and their families, fertilizer companies and their families, seed companies and their families, applicating companies and their families, entomology companies and their families, beekeepers and their families, combine harvesters, listing companies, Jordan Implement, RDO, Rain for Rent, Man Company, farm workers and their families, and last but not least, farmers and their families. And think about all the things that function in the valley due to agriculture and the income it brings. Churches and charities that will lose that money, parks and rec projects. Please think about that and take into consideration the ramifications that this solar company will bring, such as the map that Mike Cox showed with the surrounding farms. There's going to be laws that are going to be thrown on the farmers with the surrounding ag land having to do with pesticide use, chemical use. What about the dust that collects on the solar panels if that obstructs the sun rays? Please take this into consideration, and please, when you look at the future of the valley, don't see ag as a bad thing, but see it as a great thing in the future of the valley. And please do not phase out agriculture. Thank you.
Thank you. Next.
Charlie Slater, Brawley, California. I've leased approximately 380 acres of this project for 25 years. Started in 1986 with Roden and Frost when they owned the property. And I take offense to the non-prime qualification of the ground that was presented in the last meeting on Thursday. I certainly wouldn't be farming it for 25 years if it wasn't a profitable situation. I think our history and the hard work that pioneers have done for the last 100 years now or so is going to be down the drain here pretty quick with all of these projects going. They're wanting to come in and turn a fast dollar and move the property for whatever the market will allow. I think you really should consider your responsibility or stewardship as far as the land and what it's taken to bring it to this point. 25 years and to 30 years is with the temporary description just won't work as far as bringing that ground back. And I'm sure that anybody that's had anything to do with agriculture knows that. The effect of businesses, families, as Brett had said, is going to be humongous. And I just like you all to really, really consider what all it's going to entail. Thank you.
Thank you. Anyone else?
Hi, my name is Corey Wheeler with Helena Chemical Company in Brawley. And I've listened to a lot of what's been said and done and the things. And to me, I would like to see this ground being taken out of production, reconsidered, from the standpoint that it is a great economic base. I think that as time has gone on, the economic impact on towns and cities has been underestimated rather than overestimated by public utilities, by those people who were making the decisions as time has gone on. And you know, we've heard 1.1 jobs per acre, and that probably is underestimated because we have multiple crops per season. A lot of those numbers are being done in areas where there's one crop per season or per year done in other areas. And so the economic impact is far greater than anybody recognizes. The other interesting fact is that there is a rolling mechanism that occurs downstream, that there's those dollars roll up to 5-6 times from the economic base of something like agriculture, and that's all going to be taken. Nobody here, I don't think, would argue that solar power is something that is important to us as a country and as a community, but put it on the land that isn't already producing those dollars and generating those dollars. So it's a choice between a good decision and a better decision. And so I'd like to see this reconsidered, obviously. Thank you. Bye.
Thank you. Anyone else would like to come and speak to the board? If not, if not, we will close the public comment period. If you're going to come speak, please stand in this line so we can move efficiently, please.
Good afternoon. My name is Meg Slater. I am Lloyd Allen's daughter-in-law. I felt like I needed to come this afternoon and make a plea for you to reconsider. My father-in-law spent countless hours on this board and also as a farmer. And I know how much he loved the land. We spent a lot of time talking about it. I think if he was alive today, I think he'd have grave concerns over what this board is deciding to do. Take out ag producing ground and put in solar panels. I just can't believe he would think that was a good idea. Thank you.
You're welcome. Anyone else would like to approach the board at this time?
I'm Julie Reeves. I live in Brawley. I come from a farming family, married into a farming family, and I concur with those that have already spoken in opposition to the solar project. This is our future right here. We would like to leave our farming legacy to this grandchild, and I would just like to see a show of hands of those here that are against this solar project taking our farmland out of production. Can I see that? Thank you.
Okay.
Hi, my name is Mary Ann Beecham. I live north and east of Calapat, and the magnitude of these solar projects is overwhelming to me because all of a sudden they're everywhere. I agree with Mike and everyone who has spoken that to take our ag ground out of production is wrong. We have so much empty ground, desert ground, places that things aren't growing, that these projects would work. And they are close to transmission lines. But our farm ground is a precious commodity. We need to preserve it. Thank you.
You're welcome. Anyone else? If not, I will close the public comment period and turn this over to the board members. Comments from board members. Director Sanchez? Director Desert?
Just like to thank all the comments from the ag sector and the community today. That's all. Thank you.
Director Menville?
Yes, thank you, President Mendoza. I just wanted to say, last Thursday I attended the City of Imperial's ribbon cutting for the grand reopening of the City Hall of Imperial that was damaged in the earthquake. And then last evening I attended the Calexico City Council Chambers, a dedication of a plaque to Nenny Torres and for all of his service at both the City Council and in the City of Calexico. And I also want to welcome Chuck T. DeMars here from New Mexico, and we'll be hearing him a little bit later, but appreciate you coming out, Chuck. Thank you.
Director Hanks?
No comment.
I just have one comment that, Mr. Ivy, the Energy Consumers Advisory Committee, if you could involve them more in the decisions regarding the public benefit charges, the projects that are going forward, the public benefit charges, there's some concern there's a lack of communication between our staff and this consumer committee that we have, and it can be a very valuable asset to the IID. So I would implore you to keep them informed, especially as far as the public benefit charge and the projects coming forward.
Yes, ma'am.
Thank you. Mr. Taylor, comments?
No comment.
Mr. Cali, comments?
No, President Mendoza.
Okay, with that, I will close comments from our staff and go to consent. Could I have a motion to approve the consent agenda, please?
I'll move for approval.
Is there a second? Second. Please vote. Okay. Moving on to information on number 6, page 18 of your agenda, we have attorney Mr. Charles Dumars here all the way from New Mexico to talk to us today. Welcome, sir.
Thank you. Yes, President Mendoza and members of the board, Mr. DeMars joins us today, as you said, from his home in Albuquerque. This is in open session. It'll be the first of several of these conversations with the board and public, and I think the way we're going to do it is Mr. DeMars will address the board. He'll invite questions from the board, and he'll entertain questions from the public as well. So, Mr. DeMars.
And you have more than 5 minutes.
Thank you. And when I say you, I mean the board of directors.
Thank you. Let's make that clear.
First of all, I would like to, on behalf of Lawn Resource Planning Associates, which is our law firm, I would like very much to thank all of the board members for extending a contract to us to work on these extremely important issues, and appreciate that opportunity and hope we can do a good job. And bringing forth a report, a research report that's useful. There are a number of people in the audience who I'd personally like to thank who welcomed me into the community, and I talked to them about various water issues. And I have to say, in talking to the board and everybody here, there's a tremendous amount of sincere commitment and interest in resolving these issues successfully. And I would thank both the community members and the board for letting us get involved in this project. As you know, our law firm has been tasked to do a very specific thing, and that is to develop a report that analyzes the possible alternatives of what might happen or what could happen depending on the outcomes of the QSA litigation. We are not participants in the litigation. I believe we are good, objective, outside experts who can provide information to the board from which the board can make policy decisions. I'll just for the purpose to refresh the board's recollection and for the audience, we are not from here. Our law firm represents no other California interests. We have no interest in water of any kind. And we do have clients in the upper basin, a little bit on the San Juan, which is way above the accounting point, but we have no interest in that way. More importantly, I think we have worked a great deal. We've worked a great deal on these kinds of issues. We have represented the state of Oklahoma against the state of Texas when there was an attempt to do 450,000 acre feet out of Oklahoma to the Tarrant Regional Water District in the Dallas-Fort Worth area. We represented the state, and we do represent the state of Georgia in writing and negotiating an interstate compact over the Chattahoochee River. Last summer, we represented the state of South Carolina when they challenged North Carolina's attempt to move water over out of the Catawba River to Charlotte, which had effects on downstream. So we're very familiar with these kinds of issues. We also represent farmers, a number of farmers, including both in Colorado and in New Mexico, all of whom are facing the same kinds of issues you're facing here, both water rights issues and environmental issues. But the nice part about our being here is that we don't have a stake in any particular outcome. We can provide information that we hope will be useful. What we have committed to do is we've committed to evaluate what the outcomes might be in the QSA litigation, whether the Court of Appeals affirms the decision of the Judge Candie, or whether they reverse or whole or in part. And in doing that, we indicated that we would, whatever our research shows about the possible outcomes, we would measure it against the principles that you adopted recently relating to the management considerations of the board. It was a 5-0 vote, and it was called Organizing Principles of Agricultural to Urban Water Transfers. Those are the principles. And without repeating them back to you in the audience, they really they can synthesized into 4 things against which our report will measure our findings and try to make recommendations. One of the principles that's articulated is that the present perfected water rights and the overall water rights of this area must be protected at all costs. That's a vital part of the charge in your principles. That's water rights protection is one. A second one is that there should be guarantee that any solution that we might find promotes a sustainable agricultural base. That is the sustainability of agriculture over time. That, of course, means that any solution wouldn't result in the forfeiture or abandonment or loss of the possibility of that you continue to sustain agriculture. A third one in your principles is that any solution must be measured against the question whether it would ensure a long-term financial economic base for the region. one of the things that I know the chair has commented on in local infrastructure. And the final is, of course, any of those three will only work if we also are capable of addressing the extraordinary environmental impacts and mitigating the effects on the Salton Sea. So we've constrained ourselves to those four principles. We've had people send us letters and ask us to look at something else, or can't you look at this? But we'll feel those seem to be the four most essential attributes of a good solution. So unless the board tells us otherwise, we're restricting our efforts to the principles you've articulated as a board. Now, there are really, the interesting thing about this project is that it is a constantly changing legal landscape. For example, when we got the contract, you didn't have the organizing principles. On August 23rd, you have them. That's a huge help to us because it gives us some direction. Another very important thing that has happened that has changed the legal landscape, and I consider it to be a courageous act, is the resolutions, both in February and most recently, in which the board indicated it's prepared to take a realistic look at and get back involved in the Water Resources Board decisions regarding the scope and the protections of the Salton Sea. Not that the board suggests in their resolution that you're going to do it all, but you're at least conceding that something needs to be done now in light of the fact that the state of California has declined to put forward any single bit of money toward that in the bill, which they say would implement the preferred solution. That's an $8.9 billion solution. If there's no money coming out of the state legislature to do that, many organizations will stand back and simply say, let's just pretend it's getting fixed. This board took the courageous act of at least suggesting they would petition to reopen that and understand it and evaluate that. So that's another change in the legal landscape. Another very interesting change is that every project, the two entities I represent, both of them have storage, and they use the carryover storage for protection. Since its inception, the IID has wanted storage but denied the opportunity to have storage in Lake Mead. You now have a very interesting development in that the International Boundary and Water Commission has articulated through their negotiators the desire to assist Mexico, a very legitimate goal, in storing some of their 1.5 million acre feet under the Mexican Water Treaty of 1944. That is a significant occurrence, because at least it shows that storage could be possible, and if storage were possible in that context, perhaps storage might be available here. So it's at least a movement, and there's continuing. I'm sure there'll be more changes in the legal landscape, but let me talk a little bit about what's going to happen in the Court of Appeals. The Court of Appeals, as you all know, the issue in that case, there are multiple issues, but there are really two principal ones. One is whether or not it is constitutional for the state of California to agree to a commitment without a cap to pay for costs when there's no appropriation. Virtually all Western constitutions prohibit that. Whether the QSA is one of those is going to be a legal issue. And if Judge Candy ruled it was unconstitutional, conversely, if the Court of Appeals reversed and said, we think it is constitutional, in my own view, and we're just starting to look at this, but the question is, what would that mean if the state of California doesn't have the revenues and can't do it anyway? What would a court order do? How would that actually occur? If, and at least in your resolution, you've acknowledged that you haven't said it couldn't occur, but you've acknowledged it's been very difficult to get the state to take action, and that this board is at least moving forward to look at the question. So I guess in summary, that will be part of the legal landscape, the outcome of that case, but it isn't going to change the fact that you have a tremendous issue with the Salton Sea mitigation restoration, depending on how you come down on it, and that's got to be paid for by someone. And so that's just another factor, but it's not the determinative factor that some people you would think a court decision would resolve something. I don't think it resolves. It doesn't make money. It just decides whether one should pay. So we're laying out now. We've evaluated the legal contracts. We have a good handle on the legal and institutional issues. The next thing we're going to do is look at, and you have all this information, but it's helpful to us. We have a forensic accountant on staff who is going to look at some of the numbers, simply not to do an audit, but just get a sense of what the numbers will demonstrate. And then, based on that, we'll lay, with analysis of the laws and the numbers, we'll then lay it against your principles. Will there be enough revenue to guarantee the economic base, sustainable agriculture? Will there be water rights protections? And this is a gross oversimplification, but how is that going to integrate into the decision of protection of Salton Sea? Once that's done, our final part will be try to at least talk a little bit about policy. At that point, policy is you make policy, our firm doesn't. We simply inform. But there are examples all around the country that we've worked on where you have trans-basin diversion impact studies. You move water out of one area, it has an immediate impact on the area from which the water is transferred, and we'll give you some illustrations of that for your own information. And then we will respond to we will expect you to continue to respond to us with questions. And we had hoped, as the general manager has indicated, Mr. President, that we would have meetings to get input from people here. I've had some personal input from people and a lot of wonderful people here. It's really fascinating to me as a law professor and as a lawyer that everybody seems to want the same thing. They just want this valley to be here, and they want the water rights to be here. It's just a complex web of interrelated relationships that have to be worked through to understand how to do it. So basically, that's what we will do. Our next phase will be a summary of those two pieces, both the legal analysis of the framework, and that will include the federal, the state, the local, and it'll be, I think, a good summary of where you are, coupled with some comments about the financial implications and all of that measured against these 4 criteria you have adopted. So that's it, Madam.
Okay, thank you. Comments or questions from the board at this time before I turn it over to the audience, if they have any questions or comments? Director Hanks?
Yeah. Mr. DeMars, you mentioned about the changing landscape. One of the major issues in dealing with the QSA is all the different parties, all the different water agencies. Are you giving any considerations to maybe the formation of a clearinghouse so we can lessen the amount of contacts necessary with the other agencies?
Mm-hmm. That's a good, may I answer, Madam President?
Yes, please.
Yes, we're looking at that. In fact, we're looking at the way other people manage some of these complex things. We have some of our own clients where we have multiple agencies. One of the difficulties is that it is when you have everybody working at cross purposes, the agencies sometimes contradict one another, but certainly to the degree you could streamline information through one clearinghouse and get it out to everyone. I think that would be very useful, and we're going to take a look at that very question.
Is that it, Director Hanks?
Yeah, I'll have some more, but let some of the others ask.
Director Manville?
Yeah, I just, as I said earlier, Mr. Mars, I appreciate the fact that you would come out here, and I appreciate this board working together to hire you to do exactly what you've spoken to us about here today. We have a certain scope of work that the general manager has laid out with you. I'm looking forward to what you bring back to this board so this board can decide what they want to use, what they don't want to use. But just the fact that you've come with a fresh perspective, and I know that you were involved with the amicus brief that dealt with the QSA, and I know that there was a lot of landowners and farmers and local people here in the valley that participated with you on the amicus, and I think it's very important that we keep an open mind. We have the QSA, it's been invalidated
basically Judge Candy gave us a second chance to take another look at this thing. I think the main concern of everybody in this valley is to protect agriculture. It's a $1.6 billion industry, and I understand the concerns of people out here today with the solar being placed in ag ground. So I look forward to what you can do to help us make this so that we're protected here. And I know we have a real issue with the Salton Sea, and I look forward to see how you can help us with the Salton Sea problem also, which protects the valley. So thank you.
Thank you.
Director Desert?
Thank you, Stella. Could you share with us a little bit your past experience in water issues with the many different agencies you just spoke of and Director Hank's question?
Yes.
How many agencies you're working with and how different and opposing their views and positions were?
Yes, that's a great, Madam President, Member Desert. A good example is our current the Middle Rio Grande Conservancy District, which has, unlike you, I think you have about 1,600 miles of ditches. We only have 1,200, but we have 160 river miles, and we divert about 380,000 acre-feet of water a year for agricultural communities. Within that area, we have two major municipalities whose interests are many times directly opposed to the interests of our of the Conservancy District. We have 6 Indian pueblos who have prior and paramount rights. The district, in that situation, is obligated to do the maintenance on their property, so we negotiate with them over their contracts. We have the United States Bureau of Reclamation that continues to argue that they own our the facilities in our project, and I continue to argue they don't. We have the United States Fish and Wildlife Service that has a different focus from the United States Bureau of Reclamation, and we've been involved in litigation in the 10th Circuit for the last 10 years over 2 different species. And finally, we have the Corps of Engineers that controls the dam. So we have at least 8 or 9 different agencies, including urban interests, not unlike, they're nothing the size population-wise that you have, but we have exactly the same issues.
Thank you. And what kind of a scope or timetable are you looking at bringing something back to the IID?
We're looking at by March, but if there is November 21st, there will be oral argument in this case. And I am told by some, and have got 2 different opinions, of course, as with all lawyers, but I have been told that in other cases, they sometimes time it so they can release their opinions within a couple months. That would not be true in our state court system or those of Oklahoma or the 11th Circuit or 10th Circuit where I practice. But let's assume that they were to get out a decision before the end of the year. At that point, that decision will, I think getting that decision and reacting to it will really increase our time frame. We want to be able to respond to that and have something to you about the consequences of that.
Thank you.
Okay. Director Sanchez?
So it would be consequences and not recommendations until March?
Well, we would probably have consequences and recommendations in March. But if just for example, there are some outcomes in the Court of Appeals which would be, I think, draconian. One would be, suppose the Court of Appeals, I don't think they're going to do this, and I'm not suggesting they would, but suppose they said the entirety of the QSA is valid and binding and cannot be renegotiated or challenged, but the state has no legal obligation to contribute anything to the Salton Sea. In that case, that might be an outcome that would require some real attention. We might drop what we're doing. We'd come back to the board and ask for your direction. But if you got a very unusual outcome, otherwise, the recommendations would be in March.
So you'd be coming back in November? Would that be the last time we... In other words, when would we see you again to kind of get an idea of what you're putting together as far as... Because if it is a Plan B, which you're doing, I'd like to know what would you consider to be priorities to give an input as far as priorities when negotiating.
Well, I think first of all, what we're going to do, the recommendations we're going to make will be, Madam President, Member Sanchez, the recommendations that we are going to make. We'll simply lay out what we think are various outcomes, and we will label them. We won't provide priorities. That would be up to the board to prioritize. But I'm telling you, if there were one outcome in that case that had a huge negative effect, that is to say, a huge liability responsibility, and clearly violated one of your principles, then I think that one we would probably focus on, at least try to get that one out, get the information to you so that you can decide.
Well, and my reasoning is because I've heard a couple times that there may not be enough money for a sustained 30, 40 years for on-farm conservation. I would say that may be true, but I also like to see how we would rank priorities as far as upgrading our sewer and water systems in our cities. Mm-hmm. To be able to conserve 5,000 to 10,000 acre-feet of water between all of Imperial County, going from, if it's possible, from sewer to tap or for golf courses or whatever the case may be, or upgrading every sewer and water system here to start conserving water or start the process of purple pipe. Because you said water transfer, you necessarily say ag transfer.
Yeah. Mm-hmm. I guess I think all those are relevant. We would be looking at those as part of it because those are alternative ways to conserve water. As you know, the United States Bureau of Reclamation, through Mr. Bennett, Ray Lee, and others, during the previous administration, said they insisted that California could reduce its use from 5.1 or 2 million acre-feet to 4.4 million acre-feet. That's a huge hammer. And the question is, how are you going to get there with that? And one of the suggestions, what you're talking about, would be one way of saving some water. But that's, whether they reinstitute that hammer or not, that's another outcome that we would look at as a possibility in the study. But it's, they're all connected.
Would you like a bottle of water?
No, I'm okay.
You're okay? Okay. Director Hanks?
Yeah, Mr. DeMars.
Excuse me, that's not transferred water, is it?
Oh, it comes from Costco.
I was just there. I had to buy a new shirt because I got my other one dirty.
You couldn't afford it.
Well, I probably couldn't. Excuse me.
I've been very concerned about a cost-benefit analysis on the QSA. From just looking at something, I think there was a lot of missed opportunities, but there's also a lot of unknown costs, particularly in the area of environmental mitigation. To protect the IID against that, I would think that we should give some consideration to a cost plus formula to give us that protection. Some of the advice you gave us, and I think it needs to be repeated in dealing with the Salton Sea, and I believe your comment was, in seeking a solution to a problem, be careful that you don't take ownership of the problem. Mm-hmm. And in terms of litigation and mitigation costs there, I could see where that could really put us in a negative productivity mode. Mm-hmm. So I'd like to see us in consideration moving forward, some type of cost plus arrangement, just for that added protection.
Sure, and we'll look at that. If I could explain that statement, and I think it's important. That's why I said the board was courageous in stepping up and passing a resolution. And the board wasn't saying that it was the IID's responsibility that Salton Sea was having issues. Rather, the board was saying, we're not going to pretend that the issues are going away. And the board is putting one card out on the table, and hopefully everybody else in the process will follow suit and play their cards. But it certainly was not the intent of the resolution, as I read it, to take ownership of the problem, but begin the process of trying to understand and solve it.
I've got one more. Regardless of what the appeal decision is made, do you see a big difference there in the final outcome?
I think whether they affirm or reverse, I think it doesn't make any money to solve the Salton Sea problem. The court isn't, let's say that you win and they reverse, then you get sent back, remanded back down to discuss the environmental issues before Judge Candy. That part of the trial was suspended. I don't think a court decision by the Court of Appeals or the California Supreme Court is going to generate, in these economic times, $6.8 billion. You could get leverage one way or the other. People will brag on either side, and they should. They're very good lawyers on both sides of that case. But it doesn't, I don't think from where we're sitting, we're not looking at it as litigators. We're looking at it as, is there a real practical consequence? And I frankly don't see a practical consequence to it. It would be nice to, on one side, you could say the QSA is something that should be upheld because it was reflect a great deal of effort. On the other side, you could say it's an unconstitutional commitment of state funds. But if there aren't any funds, it doesn't really matter what the court says should happen, in my opinion.
Thank you.
Any other comments or questions from this board? Mr. Kelly, do you have any comments or questions?
I only wanted to elaborate slightly on Director Hanks. I think that the comment attributed to Mr. DeMars was that we needed to be careful not to confuse leadership at the Salton Sea with ownership. And certainly that's an important distinction for all of us.
At this time, I know we have some folks here that are really interested in Mr. DeMars' remarks, and at this time, if you'd like to make a comment or ask him a question, he will reply to your question. You don't have to put it in writing like public comments. So if you'd like to come forward and make a comment or ask him a question, now is the time to do so. And if you are going to come and ask him a question, please come by the mic so we can proceed as efficiently as possible, please.
Thank you, President Mendoza and the board, for this opportunity for the public to express some of our concerns. And again, I'm Ronnie Lineguber, a farmer in the Holtville area. Mr. Mars, thank you for coming here and addressing some of the concerns that are near and dear to our heart. I heard you touch on it, and again, I realize your client is the Board of Directors, the IID, and I think, my trustees are the Board of Directors for the IID, so I think we have a lot in common. I think we're real intertwined. A couple concerns that have been with mine since the very beginning of this program was, one, the present perfected rights, and we touched on that, and two, the private property rights. And we have some pretty good Supreme Court decisions that come down in favor of these private property rights that we own in Imperial Valley and our present perfected rights. And I'm worried that if there's enough bad decisions made over the years, that we're going to lose a lot of that effectiveness of those very valuable decisions that were made in the 1980s and earlier cases. And one case, is, we have it in writing that we've got a prior perfected right of 2.6 million acre feet on 460,000 acres of farm ground. That number comes out to be over 6 acre feet per acre. And it seems like I've heard that, that we're going to protect these rights and these agreements are protecting these rights, but eventually, when it comes down to an allocation, and we've been playing with that before, we're limited to this 5 acre feet that the board has been talking about before, and that disturbs me that we have these such great Western water rights that are better than anybody else's in the West, and we have these Supreme Court decisions that were handed down, and we're bypassing those, and we're making our own rules and laws, and well, it's kind of like what we've done in this healthcare. You've got to read the agreement. We've got to pass this agreement before you can read it and you can figure out how good it is. We were told that this deal's such a good deal. We can't disclose all this information before it's all proprietary and it's in the secret behind doors meeting. And the more and more of this stuff is disclosed,
the more and more it looks like we didn't get such a good deal for these great water rights that we own and possess. So my main concern is that, one, we don't diminish those PPR water rights, and two, we go back to the Supreme Court and we review those decisions, and we base everything on those decisions, and we move forward from there. And because those decisions are current, they're relevant, and they mean a lot to this valley. Thank you.
Thank you. Good one.
I think that was more of a comment and rather than a question, but it is true. The present perfected rights are incredibly valuable to the valley here, in the board as trustee is coveting those. The farmers who put them to use are coveting them. It is the use of the water that avoids their abandonment, and it was their use that created them. But insofar as anything chips away at those, that would be a horrific outcome. That's one I don't have to research, because we have the same in all of our clients that have these special rights.
Okay. Please come forward. State your name for the record, please.
Tom Sefton from Raleigh with Sefton Water Technology. Question, and thanks for President Mendoza and the board. Question for Mr. DeMars. If the appeals court ruling were to uphold the invalidation of the QSA, one, would that throw the water transfer agreements that flow from that into possible renegotiation? And two, if those water transfer agreements were renegotiated, would it be possible to negotiate on the principle that the beneficiary of those transfers should pay for the harm done by those transfers? In other words, that Metropolitan Water District, San Diego, Coachella Valley, any beneficiaries of these transfers should pay for the harm to the agricultural economy and the cost of water conservation and the harm to the drains and the environmental damage, and most importantly, what's not included in the current agreements and hasn't been seriously considered is the damage to the Salton Sea that can be directly attributed to inflow reductions due to water transfers, and what that means to dust problems and environmental damage and the cost of building habitat and mitigating dust problems and anything else such as salinity increase. If you could answer those, I'd most appreciate it.
Well, if the court upholds Judge Candy, there are a couple of outcomes. One, he could say he thinks it's invalid, and will likely say he has thus far ruled that that's triggered and they're tied to, that was an essential commitment. And obviously renegotiation is one option. You could look at individual contracts. Some are probably better than others. There are a number of alternatives that could come up. But I think that the Salton Sea issue and who's going to pay for it will have to be resolved if this is going to continue. Because if that's the part that troubled me a little bit when I first came to the Valley, was the fact that you would think that the logical payment would be, obviously, the state of California. This is a state, incredibly valuable state resource, and they would be the logical entity to pay for the loss of this resource as a function of transfers to get their water use down to 4.4 million acre feet. But if they can't do it, then it will be a question that was not answered before, and I guess let me say this, who should pay? But you can't go backwards. I mean, you can't go back and say 7 years ago they should have done this, or you have to look where we are, take it where we are today. And where we are today is, if the state isn't going to pay, then they will have to allocate that cost and also look to see what's realistically available to do at the sea, and that's what your resolution is doing, really.
Anyone else?
Good afternoon, Chairman Mendoza. Rusty Jordan from Brawley. Hi. I saw from the directive from the Court of Appeals that they want everybody to address the constitutionality. It doesn't mean they haven't looked at the other things that are raised in the lawsuit, which includes meeting of the minds, which seem to be that
if constitutionality had been overcome, they would get to that. So the presumption would be, I guess, that they haven't gotten by the constitutionality issue. Do you think that they'll come down on any of these other things? Everybody's pleading with them to please do. And then how are you doing on being removed as attorney for the other group that you represented here in the Valley?
Good questions.
Yeah. Let me answer both the last question first. I've withdrawn from their representation. They've released and provided a waiver of any conflict for the work under this research project. We have filed the motion. It is now docketed. It's set there. I had to call Friday and find out why they hadn't docketed the motion. It's a procedural order. I can't imagine there'll be any objection to our withdrawing in the case from a client we no longer represent. So that's not an issue. But I think that I'm glad that he asked that question, because the way in which the court has framed what they want people to talk about is very interesting. He is correct. There are numerous other very thoughtful briefs filed on meetings of the minds and other issues involving contract. But what they said was they'd like your primary focus to be on the constitutional question, meaning if is it constitutional for that kind of commitment to be made in the JPA? The second issue was whether or not the court should consider the California Environmental Quality Act, the CEQA issues, which have not yet been tried below, or whether that they should ever reach that. Well, at least some of the briefs argued that if they invalidated on constitutional grounds, they wouldn't have to reach that question, because then there's no commitment, and the CEQA question goes away. And I think, the other issues would also go away. Whether there's a meeting of the minds doesn't matter if it's unconstitutional. So I think they will have, if they rule it constitutional, will have to address the other issues. But the order of oral argument is kind of instructive and interesting. But nobody can predict what any appellate court will do. That's their business.
Okay. Anyone else?
Hi, Steve Benson, Brawley Farmer. I am a member of the WCAB and Farm Bureau, so I just want to put that out there. Wanted to know if you'll be analyzing any proposals for the restoration of the sea, and any proposals to work with other groups. I know you work for the board, so it's hard to say that, but I think any solution would require buy-in of WCAB. We're nominated by the board here. But then also Farm Bureau, which represents the majority of the users. Also, there's a strong public interest in this, so I don't know if you can speak to that. Thanks.
First of all, let me say that thus far working with the board, it has been a pleasure. We've not been constrained to not work with any group. We've received any information we want. They've been open about it and provided it. And we're at the case that the Farm Bureau or anybody else has some solutions or some information, we'll consider it. And obviously, they're part of the community. That's the purpose of the public meetings. But so far, you understand what we're doing. We are simply providing a report for the board. They've given us the authority to do that and said, tell us what the answers are that you think are correct. They haven't attempted to guide anything other than to put the principles that they believe control what are good outcomes, and that's very helpful to us, the four I articulated.
Also, I think that Mr. Kelly, we're going to try to have him go to one of the integrated water resource meetings as well, or at least sit on one of them. They can ask him questions over there.
I think in the next several months we'll be able to do that.
Mr. Mendoza. Oh, for Mr. Cox. Sorry.
Larry Cox, Farmer Brawley. A question, it seemed like during the negotiations for the first QSA that there's a lot of appearance that both Coachella and Met held us hostage to that thing. Is there an avenue for a transfer that would allow us to not be held hostage to junior right holders?
Very nice concept.
We've looked at that. There seem to be some of the entities got pretty inexpensive water as compared to others, but we haven't been. The answer is we're going to look at that question there, and it's a great one. I think that in the process of solving the Salton Sea problem, everybody's going to have to come up to the table, and when they do, I think that will yield lots of answers about other questions. How much revenue are people providing? And it's going to have to be a global solution. Just as an aside, one thing, my experience in negotiating an interstate compact among Georgia, Alabama, and Florida suggests that maybe you ought to look at this. If you do look at the JPA again, look at it more in those terms of, because you're really you've got one institution with all the resources, which is here but small population, another institution that's got huge demand, and I think we may want to use some of those models for figuring out how to get leverage and more like a compact than just a JPA. It would be a JPA, but look at it a little more broadly in that sense.
Mr. Dumars, one last question for me. I think for some of those people out there, you are not going to provide an opinion or discuss, as far as I think I heard, property rights, what the water being tied to a specific owner, but other than the district, you are not going to be commenting on that, only basing your work here, research on the QSA itself.
Well, our research is really going to be broader than the QSA. It's going to be, what are the alternatives to the QSA in addition to the QSA, and maybe a new JPA, maybe a new kind of agreement, maybe who knows what the alternatives would be. But we're not charged with providing any legal opinions per se to the district at all. We're simply making recommendations in the same manner as the National Academy of Science report would do. These are recommendations we think will make everybody better off based on your 4 criteria.
Anyone else from the audience would like to approach the mic at this time, please? And I'd like to finish with Mr. Dumars' presentation by 2:30.
Thank you, Ralph Menville, former IID director, and I'm not going to ask any questions of Mr. Dumars, so no one can accuse me of throwing softballs to him. But since I helped introduce him to the Imperial Valley, I'll put a plug in for him. I would like to say that he's honest. I've known him for quite a while. He is respected, and he is what the IID and the people of the Imperial Valley need to get us through this maze called the QSA. What IID and the people of the Imperial Valley do not need is the QSA in its present form. Water is a gift from God. The invalidation of the QSA was a gift from Judge Candy. We should take these precious gifts and use them to improve our lives and our communities, not squander them away for those in Coachella Valley and those on the South Coastal Plain. When Mr. Somack addressed the IID Board about appealing the invalidation of the QSA, he told the board that the South Coastal Plain was in a recession and could not afford to pay more for our water. The Imperial County, with 30% unemployment, the hardest hit county in the nation, is supposed to give one of its precious assets to Coachella and the South Coastal Plain because they cannot afford to pay for it. I have here a pamphlet that's put out by the City of San Diego Public Utilities Department, and inside it reads in a paragraph about San Diegans waste no water. It says that 80% of our water comes from either Northern California or the Colorado River Basin, and our wholesalers tell us that the price of this water will continue to rise. Many of us are tired of being ripped by the Metropolitan Water District, San Diego County Water Authority, and the Coachella Valley Water District. Ronald Reagan said, "Fly your bold colors, not pastels." Honorable board members, let's be bold. Stop wasting money on the QSA appeal. Do not extend the IID MWD agreement. Put the IID San Diego County Water Authority agreement back to its original form. Accept no liability on the Salton Sea because of water transfers. The liability goes to those getting the transferred water. And at last, stop giving our water away. Start working on drought insurance for the South Coastal Plain. Forget about Coachella. They have more water underneath them to pump than we have in the Colorado River. Think conserve and store. Let's get aggressive. Get on the offense. The minimum price should be $1,200 an acre foot. If they don't like it, they can desalt the ocean and use that water. I'm not crazy. I'm realistic. Thank you.
Thank you. Anyone else would like to come and approach the mic before we close it? Okay. Any closing thoughts, Mr. DeMars, before you?
I don't have any closing thoughts. I guess my feeling is the board has provided leadership, not taken ownership of the problem. And I'm hopeful that in some small way our report can help provide information to aid you to continue in that leadership role. Thank you.
Thank you very much. Okay, at that time, we'll conclude with Mr. DeMaris and go on to item number 7, page 19 on your agenda. DUS PM10 demonstration project. Mr. Kemp, are you the presenter? Where are you? Oh, there you are.
I'm feeling like I'm following the headliner at a concert or something. It's a little
They're all leaving.
So I'm here today to talk to you about a dust demonstration project that we hope to do. Give you some information on it before we do it. If you're all aware, I'm sure you are, that our local air pollution control district is dealing with trying to get a SIP approved, and they're dealing with the EPA, and for days like today, which is but for windy days and things like that, we would be in compliance and we wouldn't be considered serious non-attainment. But as such, I'm here today to talk about a project that we'd like to undertake. We've been working with Air District on it. We're trying to deal with some of the issues with BACM, which is the best available control measures. And specifically, I'm going to deal with Rule 805, which is unpaved roads. And the biggest or more significant part of unpaved roads is we have our own class, which is canal roads. So we want to do something with canal roads that we think gets past BACM and gives us an opportunity, we hope, to reduce the emission potentials. So the way these things get classified is we have an inventory of canal roads. We're looking for opportunities to try and pull things out of the inventory. If we do that, then I think we're being successful. And I'll tell you what we're going to do in just a second, but we don't want to lose focus of our common goal between us and the APCD, which is trying to do something about PM10, something about community health. What we plan to do is we're going to do a mitigation measure test project. It'll be on Dogwood Lateral 2 between Heber and McCabe Roads. What we're going to do is we're going to apply 3 different distinct mitigation measures. The first is to just go out and basically build a gravel road, just put Class 2 base on it. And then as a contrast to that, we're going to build a crushed concrete road, which is using a recycled product, which is concrete that we have plenty of. We're pulling out of lining projects, we're pulling out of our dumps, and hope to get a secondary effect out of that recycling. One, we recycle it, 2, we have a secondary use for it. And the third is to treat canal roads with chemical stabilizer as an opportunity to keep the dust down. We chose this site and we had some complaints this year, so I'm addressing a direct expectation of the APCD with this one. But it also gives us an opportunity in a short amount of space of having a demonstration of the receptors, if you will, of our urban populace that we continue to interact with more and more. We have 4 distinct receptor areas on this short stretch of bank, which is we have open area, we have agricultural area, we have residence, and we have recreation. So we have a playground and a retention basin where they play soccer. So it seemed like a good location to test all of these different receptors. We estimate that the whole project will cost us about $45,000, and then to get that in place. And what we hope to get out of it is, 1, we're trying to get proactive. We're trying to get up front. We're trying to get some of this stuff out of the overall inventory, trying to attack it before we're generating dust, try and get something up front. We're doing it partnered with APCD, so I think that helps the relationship we have with the regulator. We're going to get a firm idea of what it costs to place the mitigation measures. What does it place? Each one of them has a unique cost for placement. We'll be able to evaluate their durability. How long do they last? If I'm trying to negotiate with APCD to pull them out of inventory, how long can I do that based on the mitigation I apply? And then it'll give us a feeling for how we maintain it, what does it cost to maintain it, how long do we, what are the intervals and things like that. So those are our discoveries out of this. We also have a really nice road for our operational folks to drive on once we've done all of these mitigation measures. And last, and certainly what we continue to need to focus on, is we're going to do hopefully get some risk reduction on dust producing stuff and the mitigation that we're going to get out of that for the community.
Mr. Kemp, you said 45,000. The board packet says 35,000, which
that's the next one.
45.
So this one's 45,000.
Oh,
and most of that cost is
I jumped ahead. I'm sorry.
Yeah, and most of that cost is in the base for the one constructed portion that we're going to have.
Yeah, 45. The other one is illegal dumping.
Yes. So we'll get to your 35 here in a minute.
Okay. All right. And for this, you just information only, correct?
It's information. I think the APCD was here, or they were. Maybe they went back to work. Oh, yeah, Brad's here. So if you have any questions for me or them specifically.
Would you like to make a comment, sir?
I'd like to make Mike, be sure in the proof of concept that you include a proof of affordability on this, okay?
Okay.
There's a lot of canal banks out there.
Yeah. Yes, there are, which is why that inventory is so huge. And I think the opportunities we're looking for is opportunities that are about our urban areas, which is where that interaction with the receptors is so great.
Okay, thank you.
Afternoon, Madam President, members of the board. Nice to be here. We've worked with Mike for some time now since he's taken over as the regulatory compliance manager. He's been very proactive coming in to the Air District to get up to speed on what the requirements, regulations are as they apply to IID and what type of measures we can do working together going forward to minimize the impacts of fugitive dust from, in this particular case, canal roads. There is a regulation on the books right now that requires the IID to maintain their canal roads, and there's a variety of mechanisms by which you can do that. And what he's proposing today is three different ones of those. You've currently have some very innovative and how should I say it, some unique ways of controlling dust by reducing your maintenance on your canal roads. One of those was a controversial measure that was actually approved by EPA back in the early 90s when we first went through our state implementation plan, was the grass carp. You're aware of your program that you stock some of your canals with grass carp to eat the grass so you don't have to move your trucks up and down the canals as often. A couple other measures that actually the IID is taking on their own is educating your zanjeros. And I think Mr. Kemp and others in your safety meetings routinely remind your zanjeros that there are speed limits that should be abided by on those canal roads to make sure you don't create additional impact. Sometimes we still get instances where we're told that there are zanjeros driving on canal banks at excessive speeds, creating.
You don't believe that, do you? It's just.
I'll withhold my comment on that one. But I think this is a move in the right direction. And it's not only Mr. Kemp and what he's doing from a regulatory compliance. We're also working with some of your other staff on some of your pilot projects that are being proposed. And if the public gets anything out of this, I guess one thing they should know is that it's not just the IID against the county in some of these things. At a staff level, we actually work good together. We actually do a lot of good progressive work towards trying to identify and mitigate and put measures in place to reduce dust emissions. So I think this is a good step forward, and I'm hoping that you approve this expenditure, and we'll continue to work with you, and hopefully we can address the Salton Sea in the same manner.
Okay, thank you. Thank you. Mr. Cox, make a comment?
Larry Cox, Brawley. We've had quite a few fields that we've taken and put road base on ourselves, and just I think it's going to take a coordinated effort between the drain maintenance people and the rest of the district staff, because lots of times if there's a canal and then a drain ditch, we can have a nice road base, and when they dredge that canal, oftentimes they'll take and put that spoil right on top of the road base, and so then you end up with 3 inches of silt on top of it, or we'll end up with, when they have to clean the canal, they'll end up with the spoil on top of it, so it's going to take a concerted effort. Also, we'll have some of the roads that we put road base on that when a district grader comes along, instead of crowning it, he'll take and push the road base off to both sides. So now we've got a big, about a 6-inch berm of road base on both sides, and we're back down to the silt that gets chewed up. So it's just going to take a concerted effort. Thank you.
Good to know, yeah. Okay, if there's any other
I just have a quick question, Mike. On the cost on this is about $8.85 on a linear foot. Is that a reasonable cost for what you're doing, or is there a cheaper way to do that, or?
I am not going to hazard a guess to answer that. I'm working with construction maintenance. I would have them answer that question.
I know, just like Director Hanks said, make sure we find some way of doing this, because if you had to do 1,600 miles, that's like $72 million.
Yes. And we don't have that intention, but we do know that as we continue to embrace our urban partners, those are the areas where these opportunities could be cost effective and probably should be, and give us opportunities where this can.
All right, thank you.
Thank you for the information, and please keep us posted. Don't go away. Now this is the other one. Item number 8, page 24 on your agenda, illegal dumping public awareness campaign. Mr. Kemp.
Okay. On this one, and thank you, Brett. This one we worked with a different set of partners, but we're responding to, is back in June, the civil grand jury produced their report. It was mostly complimentary. I think we were very pleased by that, but they did have a recommendation in there for IID, and that recommendation is they want us to be more proactive, more aggressive with the illegal dumping that's taking place throughout the Imperial Valley and the community as a whole. So we went out and embraced the existing task force, which is, there's an illegal dumping task force. I hope you're familiar with it. And they have a subcommittee, the information subcommittee. We got working with them. And then we went out and engaged major players, people who we knew had to be intimately involved with this if we were going to be successful and have something that was going to roll out appropriately. So we embraced Farm Bureau, and we go with the Imperial Valley Resource Agency. Now what we plan to do is implement a full public awareness campaign, which means you're going to get flyers and posters and decals on vehicles. It'll be similar to the copper campaign that we ran for energy, to give you a feel for what it might look like. And this funding is $35,000, Ms. Mendoza, coming out of the executive budget. We embraced our public partners, Imperial County Department of Public Health. We embraced all of the departments in the county because there's a lot of stakeholders and a lot of people involved in the task force, but Public Health did a lot of the heavy lifting, if you will. Imperial Valley Resource Management Agency and the Farm Bureau. These were the agencies we felt we had to have, and when you see the visuals on this, you'll see all of us have the logos attached because they're the quote-unquote sponsors, if you will. But I didn't want to forget all the other partners and people that are on that task force. You have the local vendors who do trash hauling, you have all of the cities, and you have other organizations involved there that are important, and we didn't want to not include them. What we think we have here is a real good tool. It's very synergistic with our partners. We all have unique needs. We all have a unique customer base. So we had to make this modular, if you will, as an opportunity to serve more than one master. What we did is we made it so that we will have a brand, which is the tagline at the bottom, which will be common throughout. But some of the artwork may change and some of the text may change, and that provides a modularity that helps us embrace more of the people that are involved in this. We are set for at least a year. We will have 12 months of this campaign from the IID. We have an expectation that we'll get into it for 3 months periods and then have an opportunity for some of the other partners to step up to the plate, if you will. And then they will sponsor ads in that period, or they'll sponsor some artwork, or they'll have opportunities to get involved. The ads will rotate. You'll have media and all of the other things, and we'll go over those in just a minute. So what it's going to look like is this. This is Keep the Valley Beautiful. If you look at, and I don't.
Who made those ads for you? They're really nice.
Huh? Well, I just.
I wanted to give you a plug. I knew it was
I
you,
was going to
Tony.
get to Tony, and now you stole my thunder. So, but what I did want to point out about this, and to Tony's credit, and let's do it that way, and is that the artwork you'll see. We put these 3 examples up here as an opportunity to show how we hope the artwork will work with the stakeholders. So, if you're in a city, perhaps you want to put your post office, you want to put your city hall on there. So that middle one has the architecture and the opportunities for you to do that. We have some, Mount Signal might be more of a south end icon than the Salton Sea is to the north end. So we wanted to demonstrate that those opportunities are up there. But the illegal dumping is a crime. Report it, call this number, and the logos are the brand, if you will. Those will not change. Those will always be there.
Okay.
Who answers the phone at the 800 number?
That goes through the county, and right now it goes to 24-hour pagers. So it'll be staff, usually in the public health division. However, and I got an email from, I don't know if you're familiar with Jeff Lamore, but we talked about this morning, is they're going to construct that as a phone tree. It will have an automatic answer and an automatic dial so that you have an opportunity to send it to dispatch, or you have an opportunity to send it appropriately for the response we want to get.
And so the county environmental health will be the enforcement agency or the sheriff's department?
The sheriff's department is enforcement, but the manager of the number, if you will be Imperial County Public Health Agency.
And we have sheriff's department buy-in on participation for enforcement?
They are stakeholders in the committee, yes.
Thanks.
A little bit more of the opportunity and the modularity is here in the campaign advertising. You'll see you can do color, you can do black and white. If I could call out on the one on the left here, it says Keep the Valley Beautiful, illegal dumping is a health and safety hazard. That portion is the opportunity to be able to put unique messages in there. That portion is the unique opportunity for different stakeholders to be able to put unique art in there if they think it's appropriate. So that's how we've embraced our partners and given them the opportunity to quote-unquote share the campaign. And then the posters on the right are very similar, is that the middle section of the poster is the opportunity for specific messaging. So that's what we have. We expect to spend that amount of money. It's going to roll out very soon once we are sure that you're on board with it. We shared with the Farm Bureau and Public Health, and I think Lindsay is going to have a comment.
Of course I have a comment. Lindsay Dale, Farm Bureau. I just want to commend your staff. This was the original concept somewhat from Farm Bureau, but I tell you, Tony and Michael just took it to the whole new level. And
we have the best of the best.
Absolutely. I mean, these guys were fantastic to work with. We got the complete buy-in from the task force immediately. They were so excited. We identify the valley as being so beautiful, and I think that this has a couple of different legs. It encourages people to report when they do see illegal dumping, but also it brings pride to our community and to our residents, and reminds them of the beautiful aspects that we do have in Imperial County that sometimes we neglect to see, or some people neglect to see. There's so many different beautiful places in Imperial County, so a lot of different pictures can be interjected here, and I do see a lot of different legs that this campaign could take on. For instance, with the city, maybe an anti-graffiti, or with the schools, just interjecting different photos and different words, but keeping that tagline, Keep Imperial Valley Beautiful, or Keep the Valley Beautiful, has a tremendous opportunity for us all. And I want to commend the Farm Bureau, or excuse me, the IID for stepping in and helping us out with that, and to our Farm Bureau also for taking the lead and starting this process years ago. I think it was our harping on the Board of Supervisors to identify this task force years ago, and this is some of the process that we've made in it.
Thank you.
Thank you.
Thank you, Mr. Kemp.
So information only. I want to make sure you're aware, and we will start rolling it out as soon as we can get it prepared.
Thank you.
Thank you.
Thank you, Tony, as well.
President Mendoza,
yes.
I don't want to let it pass without referring your attention to that Mount Signal photo. I'm sure that is one taken by Marvin Wieben here in El Centro, and he's very gracious about lending those images to IID and others at no charge.
Oh, that's good to know. Thank you. Moving on to item number 9, page 31 in your agenda, Water Department General Matters. Mr. Villalon.
Good afternoon, Madam President. A couple items. One is just a quick update on New River siphon work. The structural work will be done this week. The spillway was scheduled to be made operational and available to dispatch today, so they could exercise and make sure it's operable.
1 month from today, you said it was going to be completed. November 4th.
We're pretty much done. There's just some cleanup work, some fencing work, small drainage work to be done by Friday. Next week, we will schedule a meeting and the site inspection with the Bureau of Reclamation, who have been working with our staff continuously to this project. Subsequent to that, FEMA will be here roughly at the end of this month, in a week and a half to 2 weeks. FEMA inspectors will be down here also. IID staff has also been in contact with them continuously on any changes, any additions, any problems we were running into, and making sure that we were okay with whatever requirements they had. Everything looks really good. We should be done and certified with the work end of this month. And subsequent to that, we will work to then document for submittal on the reimbursement amounts we will be filing with both FEMA and the state of California.
Any comments or questions from the board? Anything else?
And just a little bit on this microstorm we had today, real quirky. One of the South End Division supervisors tells me that one of the farmers had a rain gauge out in his field between Calexico and Holtville. They measured about 3 inches of rain. Wow. We had sheet flow across fields into drains. We will be inspecting both drains and primarily lined canals for any erosional problems, erosion around structures, because we did have sheet flow across roadways, across canals, and into drains. So we'll be providing some update on that to see what kind of damages, if any, we had. Water did continue to flow both in laterals and in drains. We did have a few plugging issues, but the guys were able to work those out and clean out drains primarily and keep the flow going, even though the drains were basically up to the rim from bank to bank in the drains themselves.
Okay. Okay, that's it?
That's all I have, unless you have any other questions.
Any other comments or questions from the board?
Do you have a number for us on the projected overuse?
Yes. We've crept up a bit. Last couple of weeks, we were in the low 70s, mid 70s. Today, the Bureau reports 83,400.
How much?
83,400, representing about 3% of our approved order. We did submit a modified order. We'll see how that impacts the projection, but we're very likely to be over our approved order in the 50,000 plus magnitude by the end of this year. We will see how this small rain in a fairly limited area impacted our orders next couple of days. Unfortunately, it wasn't valley-wide, but we'll see how, if any, impact it had on the weekly master order.
Okay. Thank you, Mr. Villalon. Moving on to item number 10, page 32 on your agenda, update on canal dredging program. Mr. Curtis?
Good afternoon, President Mendoza, fellow directors and staff. I would like to just go over give you an update on where we're at with the crane today.
Have you used it at all?
Not yet.
When do you plan to use it, in the year 2025?
No, it's going to go into service in December of this year.
I want to be there when you do that.
Okay. Well, first of all, I'd like to invite all of you to go out. The crane's located on Worthington Road, just east of the railroad tracks on the district property. You can go by there and look at it and get up in the seat and
No, I don't want to
handle
do
the
that.
controls if you like.
Someone will come flip me over, I know that.
Okay, well, this purchase was approved December 28th, 2010 for $800,000, and the crane was purchased. See if I can get this to work. Next one. This was for the canal dredging program, and the crane was purchased for about $744,000. And that included the crane and 160 foot of boom, transportation, the headache ball, lifting block, the fair lead attachment, and we repainted the crane. And there's still a committed cost of about $39,000 for the dragline bucket, which will be delivered at the end of November.
Go back to the first slide, please. The Bureau has, is it the same one that we bought for $800,000? They bought for $10 million?
No, I put that in there. The Bureau just recently purchased one for $10 million.
Is it the same model as the one that you?
No.
Well, because
The one that the Bureau purchased is a cutter head dredge. It's a floating
But what did you put
dredge.
there?
Just for some information for you.
But
just
but
a
it's
cost
not-
comparison.
But it's not the same.
No, but it's just
So
it does the same job
You're
though.
comparing apples and oranges.
Well, it does the same job.
It
So
does the
it's
same
just-
job?
It does the exact same job. But the Bureau has a lot more money than we do. They spent $10 million on the dredge and another additional $10 million on piping and transfer pumps. So they spent approximately $20 million.
And they could have bought one like this?
No. Ours was more budget based, is a nice way to say it.
So okay, let me get this straight. What you're telling me is that for the one that we bought for $800,000 is comparable to the job that can be done to the one the Bureau bought for $10 million.
No, it's not. The Bureau's machine floats in the river.
Yeah, I know.
And it has, ours has to work off the embankment. And it only has a reach of 110 feet. The Bureau's machine can float all around the river.
So it's not the same.
It does the same thing. That's what I said.
I just asked you, does it do the same thing? And you tell me no.
No, I
Okay,
said
never
it
mind,
cleans
go on.
it cleans the sand out of the
Go on.
channels of the river.
Probably not a real good idea to include that on this.
How about next time, just please.
Okay. Too much information's not good
Well,
sometimes.
It's not relevant information. Okay.
Well, anyway, we had $800,000 budgeted, and to date we've spent $783,000, so we're under budget. Okay, this week we are doing certification for 2 heavy equipment operator 2s and 2 operator 1s. That's a state and federal mandate for any crane. They began practicing on the 23rd of September, and they'll be certified this week and have their certification. And the training cost is $6,400, and that's through our 2011 resource budget. It was not included in the purchase of the crane. That's in our O&M budget.
Yeah, but it's kind of misleading because if you didn't have the train, you wouldn't have to train these. So it should be all one. So you're over
Okay.
800,000
No.
because
not really.
if you didn't have it, you didn't have to train these guys.
But we included it in our budget for this
I
year.
understand, but whether it's in budget or not, it's part
Okay.
of the cost.
Okay.
It's not $10 million.
It depends
but
on, okay,
Well.
we'll go on here. Okay. No, I'm not trying to hide the money, but
No,
the
I'm
money,
just
the
saying-
money wasn't included in our budget for 2011 for training and travel.
I'm just trying to track the cost, and so you
Okay.
add the training because without the training you can't operate the crane. So it's part
No,
of
that's
the,
correct.
It's
So
part
it's-
of the cost of the purchase.
So we're over $6,400
There you
on
go.
there. Okay.
So you're not under.
Okay. But we'll save a lot of money because we won't have to use our hydraulic excavators. This thing's a lot more productive.
Hey, we could lease it out to the Bureau too.
We could, and there's other agencies in Arizona that probably like to rent it from us.
We could float it, put floats on it.
No, ours doesn't float.
No,
It's float on
but-
the buoys.
But we could put it on a barge.
Okay. Now you want to go buy a barge?
I'll save that for next year. Okay. The operation of now this is a crane. It's not a drag line. Okay. This is a crane but it's intended for drag line service. It has the boom is constructed in a different manner. It's made out of angle iron and not tubing. So this was a special unit that we ended up. It took us about 1.5 years to find it. But once it goes into service, it's probably going to start on the High Line around January the 8th.
What time?
In the morning?
Like 8, 9 o'clock, 10 o'clock?
Oh, no, it'll be earlier than that.
Like,
It'll probably be 6 o'clock, 5 or 6 in the morning.
could you notify the board? I think we'd like to go see it.
Sure.
Yeah. I'm interested.
I'll send, if you'd like, I'd send you all an email and
Yeah.
give you the address where it is, and you can, it's right here in Imperial. You can
No,
come
no,
by.
when you start the actual work. I
Oh,
want to see
absolutely. Absolutely.
that.
We'll
Better
do
make it
that.
more like 6.
Okay.
Okay.
This is going to be a Sunday, too.
Send me the email anyway.
But the plans are to do the Highline Canal, the Central Main, the West Side Main, and probably in the future there's some work for it on the All-American Canal as well. And I would like to thank Francisco Pena for putting a good presentation together that I flubbed up, and also Fred Pumphrey and Ernie Loya. And then there's 4 operators, Danny Smale, Clarence Spence, Matthew Vogel, and Matt Kloska. And they've done a real good job becoming familiar with the crane, putting it together, and I think it's going to be a real success.
I hope so too. I look forward to it. Thank you for the
Okay.
Thank you for the update. Any questions or comments from
Yeah.
the board?
I have a question. The boom is 110 feet long.
The boom we have in it currently is 110 feet. We have 160 feet of boom.
Wow. So at 110 feet, how far out can you go with a drag line?
It'll throw all the way across the High Line.
And so that's why we don't have the 160 feet on that. We only need 110 feet.
Right. Well, if you put more boom on it, your capacity goes down, so
Right.
you have to have a smaller bucket.
Right. Right.
So we wanted to maximize the size of the bucket with the
So
reach.
it meets our needs. It meets our needs at that height. That maximizes
Yes.
the amount of soil we can move.
Absolutely.
That's my question. Thank you.
Okay.
Thank you very much, Mr. Curtis. Moving on to item 11, page 38 on your agenda, Energy Department General Matters. Mr. Ivy.
Thank you, Madam President, members of the board. Just briefly, the IID Energy Department has posted a short list for a request for proposal for up to 30 megawatts of solar power. And speaking of solar power, and so we are also going to shortlist, which is imminent, to post through a SCAPA process as well, hoping to get the approximately 30 megawatts out of this. I intend to bring to the board on some frequency, monthly or quarterly, depends on how valuable it is, some amount of operations metrics to the board. But I just want to give you some examples of some things that we're considering. For example, for the month of September, we had 43 distribution circuit outages, and that impacted 13,538 customers. So it was a pretty busy month for the distribution folks. In terms of our DG program, we have year to date, we have installed capacity of 3,604 kW, which is a pretty good number. And that represents roughly $3 million in rebates, which is about 75% residential. Our generation portfolio, we're looking at that on the performance of the portfolio on an equivalent availability factor basis, which is essentially how much is it available over the time period that you're measuring against. So it's the performance of the units, less outages, essentially. So our hydro units, as you would expect, would have a high number, and they're coming in at 94. The El Centro generating station units are roughly about 71. Gas turbines are about 78. Yucca is 68, and San Juan is about 88. And from my experience with San Juan, that's pretty typical for them for a number, maybe even a little high. We also, year to date, we've had reported 28 OSHA recordable injuries, which is an area that we're going to be emphasizing in the very near future, trying to come up with programs and things that we can do to address that and keep bringing those numbers down. I think we've had some good progress, but anything over 0 should be unacceptable to us. And that's the end of my comments. I'll be happy to entertain any questions if you have any.
Questions or comments from the board?
Joe, when will your short list on the 30 megawatt solar go out? You said you're putting out a short list?
The short list for the IID RFP process is out and posted. The short list for the SCAPA portion, which is a few more projects that we're considering, is imminent. It should be out anytime.
Okay. Any other questions?
Yeah, Joel, the price you gave for the Yucca plant, could you go over that again?
That's the performance index of the units, so equivalent availability factor. Sorry about that if that was confusing. So that's how the units performed year to date. So you can say it was available, did you say Yucca?
Yes.
Roughly 68% of the time.
Because Yucca is one of our more expensive sources. Thank you.
Mm-hmm.
Okay, any other comments? If not, we will move on then to item number 12, page 39 in your agenda, energy cost adjustment update. Ms. Ainsworth?
Good afternoon. Sandra Ainsworth, Controller, Energy Department. I've got a brief update for you on the August 2011 ECA. Excuse me.
Look at that.
I apologize for that. So a quick update on the August 2000 ECA. I tried to make the font as large as I could. There's a lot of information to get on this slide. So essentially what you see on the projected on the screen is the calculation for the August ECA and our energy cost adjustment. So energy, fuel and purchase power costs are approximately $27 million for the month of August. And you can see we've broken it down according to the ECA schedule. And there's a subtotal for base rate component cost and ECA applicable cost. Excuse me. We ran that through the calculation, and from the month of July, we had an overcollection of $201,000. We added that into the calculation. So once we run this through the calculation, the result is 3.64 cents for the calculated ECA for the month of August. That is compared to the rate of 4.19 that is in effect. And that results, when compared to the 4.19, in a approximately $2.3 million overcollection for the month of August. Excuse me. And that overcollection would be rolled into the calculation for the month of September. So we wanted to bring this to the board and update you before we post this on the website for the customers. And just as a quick update, this is actually what we're planning to post on the website for the August calculation, as opposed to the rather large worksheet that was posted for the month of July, unless there's any objections by the board.
No, this probably makes it more efficient.
Mm-hmm.
Questions or comments from the board?
Are you saying that we charged 0.364 in August?
No, if we
would have.
If we were going by the calculation each month, then it would result in a 3.64 ECA, as opposed to the 4.19 is what was actually billed in the month of August.
So in September, are we bringing it down to 0.364?
The board has directed that we'll leave it at 4.19 through the end of the year and revisit it as part of the budget process this year.
What we're
I thought we were going to true up by the end of the year.
Yeah, there is a true up. What they're doing, it's lagging a little longer than ideal, but every month following the previous month, they're going to come to the board first as a draft, then they'll post it, and then here in December, probably actually January, you'll have a complete picture of what looks to be an over collection. You'll make that adjustment for
the following year,
and then in 2012 the intention was to have a floating ECA that would adjust perhaps quarterly.
So we're going to be working. It's kind of like I guess I just wanted to know what the options are. We're going to look like we're going to be paying forward or paying in the rears. And you pay a cable bill, you're paying forward or you're paying in the rears. So it sounds like we're going to be paying forward and not necessarily paying in the rears. As far as chewing up the.
I think that's probably right. You're going to defer just because the true up won't occur until you've got the full 6 months the full 6 months to review. But that 2.261 million is 100% over the previous month, and I think there's probably some work to do in figuring out why that happened.
Yes, one thing I wanted to point out. Yes, Director Sanchez.
Well, I was just going to quickly say that money it's put into a separate fund than the general account, right?
It's separate from the rate stabilization fund as well, which is capped.
Is it treated as, I don't know if there's brokings here, is it treated as will it be treated as an expense or will it be treated as positive cash flow?
Eventually, it'll be treated as an expense because we'll lower our expense or our calculation for any over collection.
So for this year, it'll be treated as a positive cash flow.
Well, the way we have it planned, or the way we think the board will make their decisions after 6 months, if there has been an over collection, it will result in a lower ECA rate going forward.
So we're going to true up come budget time, and we'll come out with a new floating ECA. But this money, this over collection that we have now from July and August, is going to be tracked separately than our rate stabilization account, which is currently capped at $100 million.
That's correct.
So it'll come back into the ECA formula, or it'll come back to the ratepayer in some other manner.
That's correct, as the board directs.
Going back to the ratepayer.
Right, and what we're working on right now, since the summer month is actually, the summer is complete at this point, we're working on updating our forecast for the power supply. We've got a much better idea of what those costs will be, so that we'll include an updated projection for the 2012 ECA as we present that to the board.
Is perhaps an explanation on this difference between July and August, and the $2 million difference has to do with some other type of accounting that we were doing a month ago, or creative accounting, the way we were recording this, or someone was reporting it that's not here with us anymore?
No, we don't engage in creative accounting or reporting, but what it does entail is we looked at that. There's a few things that are going on. We've got some additional wholesales that we recognize, approximately $500,000. The Yucca plant was down for 2 weeks, so we sold some gas that we had. Then in addition, we've been working on rebalancing the meter reading routes. That effort began in July and will be concluded in the month of November. So there's a little float of when some of those accounts are billed. And one of the things that we think may be driving part of the difference is the amount of KWH being reported in the month of August. And so we believe that will normalize by the time we're complete with the rebalancing in the month of November.
So the KWH reported is less than what we are anticipating? Because $2 million over collection than what we did a month ago, that's a little bit more than float.
It's higher. Actually, the KWH sales are higher. So to the extent your divisor is KWH, so to the extent KWH sales are higher, that reduces the per KWH ECA.
So it's safe to say that the ECA is still over collecting?
Well, it did for the month of August. For the month of July, it was over collected $200,000, but for the month of August, it was cumulatively $2.3 million.
So it's $2 million difference between August and July.
Approximately, yes.
That's a significant difference. So it'd be interesting to see what we do in September.
Yes.
What would be the safe number? Plus minus 10%? Like, is it the 200,000 or is the 2 million going to be the norm when we do this quarterly next year?
Well, just compare this against the scenario that we expected when we repegged the ECA, I think in April, to take effect in July, and that was that we would end up under collecting, and we'd have to replenish from the rate stabilization fund.
Right.
Now there's still time, and August obviously is a pretty intense test, but we're going the other way right now.
I think those estimates we were going to be burning up our rate stabilization account upwards of $25 million a year.
Well, we were certainly thinking that we would go through the rate stabilization fund on a fairly rapid over several years pace.
As it is, we haven't touched it. In fact, we've added to it. If
Well,
anything.
based on these 2 years, and I should say that the energy staff, this is a much better depiction, I think, than the one we gave the board previously. But it is a struggle to produce this, several weeks after the fact. And the way they're doing it is they bring it to the board first before posting it, so that they have some confidence in it. But that same level of confidence has to extend to why it's this way, and I think that's to come.
Yes, that is. And one other thing I would like to point out, in looking at July and August and comparing the 2 months, fuel and purchase power cost as a total only increased approximately $200,000 between July and August, whereas sales increased by a much larger amount. And one of the drivers for that is that the market prices were also down by about 5 or 6% for energy and fuel prices from July to August. So that also benefited us, where we went out to the market and made purchases.
Okay.
It's going to take time to develop your baseline for the ECA, especially the way the economy is and fuel being as cheap as it is. It could be misleading, but the projected budget for next year, if we kept the ECA where it's at now, with the projected budget, it would require a drawdown of about, if my figures were, I estimate about a little over $4 million. We have $2 million here, so things are just kind of just seem to be moving. But as we bring in the renewables, we'll see that gradually encroaching, and that's what that rate stabilization fund, where it'll come in handy is whenever the renewables come in, we can offset some of those costs.
Thank you.
Thank you.
Going on to, this is an update for the El Centro Unit 3 Repower Project quarterly update. It's number 13 on your agenda, page 43. Mr.
Tadiosian.
Tadiosian?
Close.
Pretty close.
Pretty close.
Mr. T.
The secret is to say every letter. So, good afternoon, Madam Chairman and board members. Here to just give you a brief update on Unit 3. This is what we'll go through today. This is one of the recent photos of the plant, and there's a number of cranes that you'll see there. We're actually losing 2 cranes. One's been because of the state of completion. Mechanically, we're largely complete with setting all the major equipment. We have 1 crane that's currently being disassembled. We're taking an outage on Unit 4 next weekend for a day, and that's to allow the crane that you see on the east side of the turbine building that we use to lift stuff through the roof. That crane is going away next weekend. The gas turbines are both installed. We're currently putting the enclosures together, and they're probably about 80% complete. When we finish those, we can do the final alignment on the gas turbines. This is a picture of one of the heat recovery steam generators. They're pretty much all put together. Piping is largely complete on the HRSGs, and we're working on the piping going into the turbine building. This is a view from the top. You can see the steam drums up there and silencers. This is a picture of the condenser the new condenser that we put into the turbine building. Those are all the tubes that you're looking at the ends of. And as I mentioned, we had a large crane on the east side. This is the generator that we lifted up and over into the roof and set that into the turbine building. And this is inside the turbine building with the generator. And I think you may have all heard the term the subskid. We're briefed on that previously. And so, oops, wrong one. The subskid is what it's sitting on and stretches across there. And these are what you're looking at there, and there are a couple of electrical prefabricated modules that have got stuff associated with the steam turbine that were also installed through the roof. Siemens, the original equipment manufacturer for the power island, they're roughly 99% complete on engineering. Really, it's just some stuff we'll have to do on the control system and responding to engineering and field issues that are coming up. ARB and Worley Parsons, they're about 85% complete on engineering. They will finish their engineering November 4th is their schedule. And really all that's left to do is to finish the electrical design and respond to field issues as things are being built. Most of the equipment has been delivered and a good chunk of it has been installed. All that's really left are the gas turbine starting cables. We have some more coming, and the condensate pumps, which should be here at the end of the month. On ARB's side, again, a good chunk of their equipment has been delivered and some is installed. Since this slide, the aux transformers are now installed. The flash tank has gone from being in transit to installed. So there's a lot of progress that's been made on setting equipment. As far as construction goes, all the underground foundation work is largely complete. There's still some conduit being run, but it's largely done. All the major equipment, with the exception of the steam turbine step-up transformer, has been set. As I mentioned, the subskid's complete. A lot of the piping is complete. Most of the cable tray has been installed, and the planned was 51% at this time. We're 46% complete. And there's really two issues that we're dealing with. One is that some of the design information for the steam turbine was late in getting to us, and that has dragged out the electrical design, which is causing electrical to lag. And the steam turbine came a little more disassembled than we anticipated, and that's led to more erection work to be done on site. And even though we're not done with the plant yet, we've actually started preparations for commissioning of the plant. And that's basically part of our effort to make sure we've got a good plan, no surprises, and commissioning goes off without any hitches. And that's our presentation. Are there any questions I can answer?
Questions, comments from the board? I'd like to thank you for the update. I know this is a huge project. There's a lot of moving parts, and so I appreciate you coming and informing the board on your process.
All right,
and
well,
the
thank you very
progress
much.
you're doing.
And appreciate your time. Thank you.
Before we go on to item number 14, let's take a 5-minute break. I give these guys 5 minutes and they take 10 minutes. Let's start. We're now on number 14, page 56 on your agenda. This is Mr. Brokey?
Yes.
Yes.
We have the opportunity to update our SAP system and develop a fund accounting system which will allow us to track the sources and uses of funds better, and also allow the district to budget better and more efficiently. So we have a 2-step process planned for this upgrade. The first phase 1 is to hire a consultant. We're going to send out an RFP to get a consultant in here and work with district staff on developing the objective and scope of their work, and determine, what we can do and do it cost effectively. And then once that study is done, we'll develop an MWA and bring it back to the board and discuss it to see whether we want to move forward with the project or not.
I have a question, Mr. Brokey. Why do you have to hire a consulting group? Why you don't have the knowledge or the expertise in-house?
No, we do not have the knowledge or expertise to do this large of a project and developed everything that will need to be done to SAP to make sure it works. You know, at this point, it's kind of unclear exactly how much it will cost, and that's one of the reasons why we need a consultant who's well versed in this area to come in and assist us.
So what do you think it's going to cost, more or less, approximately?
Well, depending on who you listen to, the range that I've heard, and I wouldn't be bringing it back if it's on the upper end of the range, but anywhere from $1 to $10 million. So obviously, if it's on the upper end of that, I'm not sure that it's going to be cost effective. But we think the first phase or the assessment can be done for less than $200,000. We will be bringing that service agreement to the board for approval after we go out with the RFP process.
Director Hanks?
I think you're well, first of all, I'm going to jump on this bandwagon. Okay, we just had a action here a couple of months ago where we basically wrote off like 1.7 million because we didn't have a fund accounting system that kept up to date, kept us current. So in the long run, I can see where this would save a lot of money. This would also keep our our CSPs pretty much current. The additional cost, SAP has a lot of functionality that will serve our need. We do have some quirks in our business, but if we can keep the departments to keep it as close to the STEM or the system without each and every person wanting their own little trademark.
I agree. We're going to standardize the process as much as possible. We're not going to do too many things that aren't off the shelf.
You've had a lot of experience with different utilities. Do you know of another utility that doesn't have a fund accounting system?
No, I don't.
Mr. Brokey, I know Director Hanks and I are on your budget committee, and you've brought this up and discussed it, and I think this is very important that the IID moves forward on this because, as you say, at the end of each workday, we need to know who owes us, what we owe, and how much we have. And I think moving forward, I know this is going to cost in the millions, but it's going to save us millions and millions as we move forward. So I think it's very important that we bring this forward and get the district up to par where we should be for an organization this large.
Director Hanks and then Director Sanchez.
You'll continue to work with external auditors and make sure they have all the functionality that you need?
Yes. It'll be a group effort.
Director Sanchez?
I think this question is for Mr. Campbell because IT isn't here. But I think we currently pay every 3 to 5 years as far as to continue to have SAP upgrades, et cetera, et cetera.
We pay an annual maintenance fee, and on we have like on a 3-year track record of doing an upgrade with SAP.
When we talk about consultant, are we talking about hiring somebody from SAP to write the program for us?
No, it would not be a written program. Again, it's functionality that the base SAP system has. The issue is how do you configure that for the district?
I guess my question is, does SAP have people who would help us at a discount because we are purchasing their product?
SAP does have resources, but SAP, in my experience, has never provided a discount for their skilled resources. You're better off doing the RFP and going out. We've done that in the past. You get a better price and usually have a better skill set.
Have we thought about I'm not sure it was a blanket situation, but a person who's really familiar with SAP and just put him on payroll, because we seem to be having to, do a lot of work with SAP, so to speak.
We, in the budget for the last 3 years, what we'll have found, and we are continuing to do, there is a budget line item for consulting services, and what that, and it's not a very large amount. It's like $50,000 for each of the groups: water, energy, and some of the general services stuff. So it's between $150,000 to $200,000. And that's what we do. We go out and we engage a contractor to help us with augmenting the existing skill set, because in operating a system like SAP, there's a couple of things you have to be dealing with. One is keeping that which you have running, and there's a lot of changes and little tweaks that happen on a daily basis. And then there's some additional functionality that you'd be looking for. The additional functionality is where we usually bring in the external resource to help us engage in making new configuration for something that we do not have experience in.
Okay, any other comments or questions? Yeah.
Greg, we've used SAP in the past, and we've also worked with increasing our SAP functionality for other specific tasks. And have we always been successful when we've tried to enhance SAP or pick up another usefulness of it? I know you haven't been here all that.
Yeah, I think I would defer to Mike on that question.
Have we been successful as we've done this in the past with SAP?
Needless to say, I'm a little biased on the response. I know that before I got here, there were a considerable amount of issues and perceptions regarding the SAP system. And through that course of time, one of the first things that I did bring back to the board was we need to get on track with an upgrade methodology and how we can improve the system. And the board did give us permission and approval to go through a process where we engage the district to identify what are the major considerations of pain points, and we worked diligently with all the departments and a large group of people to talk about, is it a configuration issue, is a system enhancement issue, and we put those things in place. Is everything that's been upgraded meeting everyone's expectations? There'll always be people who wish the system could operate better. There has been a greater concentration, as Greg has identified. One of the successes is how do you standardize close to that which the system has versus customization. And where the district had gone astray in the past was customizing the software, which makes it very difficult to put in new enhancements. So we've worked diligently to get back to the standard off-the-shelf kind of activities. That functionality sometimes meets people's expectations and sometimes doesn't. Every new system is going to have some quirks with implementation.
Greg, are you an SAP fan? Can we make this work for you, for your needs?
I am confident we'll be able to make it work for my needs.
Thank you.
Okay.
Jim's got a question.
Jim.
I'm just going to throw my 5 cents in here. When SAP came online, SAP was badmouthed by staff. We heard it all out through the district, through the valley. Anytime you have come in with a new system like that, and you have to retool, rebench, and retrain, you're going to have those resentments. But there's probably not very many other packets as complete and as valuable as SAP out there on the market. But it's something that you go through. And now that with technology changing over the years, there's some of them like me, like I say, I still take my buggy whip to the car. But there's a lot of these youngsters coming on, they don't have those hang-ups. And a system like what you're talking about, they'll pick up and run with it. And the more progressive older people.
Okay. So are you going to bring this back
Yes,
for approval at the next meeting?
Not at the next meeting. We have to get the RFP out, but as soon as we have the service agreement ready, we'll bring it back.
Okay, thank you, Mr. Broken.
Mhm.
Stay right there. You're next.
Yes.
Number 15. 2003 Electric System Revenue Certificates of Participation refunding.
Yes, there's an opportunity for the Energy Department to refund a portion of the 2003 COPS. There's currently about $65 million outstanding. We're looking at refunding right now about $20 million worth based on market conditions within this past week or so. If we refunded those $20 million, we would have net present value savings of about $2 million or 10%. And so we can do a portion of them now, and then as we get closer to 2013, when the bonds are callable and negative arbitrage would be less, we could, if market conditions hold, we could even refund more of those bonds.
So we're going to spend how much to save how much?
Well, the savings I quoted include all the expenses, so that's net of the expenses.
So how much are the expenses?
Depending upon whether we use one or two rating agencies, that's probably 75,000. Financial advisors probably 30. Bond counsel is probably around 50. Those are the major ones.
Say $200,000 or $250,000, $300,000 to save?
Probably around 200,000, I would say.
Okay, that's all I wanted to know.
You said refund a portion. We don't know out of the 64 million yet.
Yeah, I'm concentrating on the maturities that give us around 10% savings. Right now, that's about 20 million of the 64 million.
With long-term rates going down, why wouldn't we do the entire thing?
It's the negative arbitrage associated with taking these bonds out now. It reduces the savings considerably. And in some cases, there are no savings by refunding the bonds because of negative arbitrage.
Are these bonds how many years? 80 million.
The last maturity is in 2028. They're 25-year bonds.
Would there be still negative arbitrage if you were to reduce the amount of period, for example, from 25 down to 15 years? As far as instead of going to a 25-year loan, go to a 15-year loan. With the savings of interest, those 10 years, and a lower interest rate.
No, the negative arbitrage would still be there because it's to the call period of 2013. And then we just have, we may not have the savings because we've shortened the payback period. We didn't look at that scenario because that has a possibility of increasing the near-term debt service payment if you shorten the maturity.
Okay. Right. And you'll bring this back at the next
Yes,
board meeting?
right. We're hoping to close actually next month. So I think right now, the last meeting this month, we're hoping to have the first set of documents to you, the first round, and the second set or final approval, the first meeting in November.
Okay, very good. Thank you.
Just one quick question. Greg, on the 64 million that's outstanding, you said you're going to refinance 20?
Roughly around 20. It depends on market conditions, but right now we can refund about 20 million to get us to 2 million.
Are you going that into another 25-year bond, or is it a 15-year or 10-year?
No, it's the same period. So when you do a refunding, the maturities don't change. They're the same period as the original issue.
Okay, thank you. Item 16, internal auditing section. Where's Mr. Kaiser?
Retired.
No, he's still working.
Good afternoon.
Good afternoon.
Madam President, Mr. Kaiser is not here. Okay. So, internal audit, we don't have any off schedule, any other unusual business going on, but our normal audits that's on the schedule. And so we don't have anything else to report unless you
Board
have any.
members, any comment? Director Hanks?
Yeah, I would ask that the board support my request in circling back and doing another audit on Coral Energy and the work that they're doing with us on supply and trading.
Coral Energy's activities for the supply and trading.
Yes.
Do you want to do present? You want to us to go back and compare to, we had a couple of years ago an audit, we had some activities and recommendation then.
Yeah.
Started there.
Are they still selling the natural gas for us, unused natural gas for us?
I wouldn't want to speculate on what exactly doing for us right now, so. Sandra, maybe? Or Mr. Ivy?
I do know that they are still heavily engaged with us, so if we're not doing routine audits, we certainly should be doing.
Okay.
That would be, I concur with you. Does the rest of the board concur?
Sure.
Yeah, okay. Add that to your list.
Then, so would you like us to add it up to finish up the audits that we're working and add it up to our
there's no
upcoming? Okay. Thank you.
And also, as we're coming close to December in the new budget cycle, and we're going to be contemplating the floating the ECA or truing up the ECA, would it be prudent to have the internal auditors do a second look at where we're at with ECA separately?
It's the board's decision.
It might well be.
Not that we're looking for something just because we need another 30 days or 60 days to process it, and that way we would have something separate to look at and take a look at as we are also taking a look at it from the board's level to incorporate it into the new budget.
Yeah, I think probably that if I could speak with internal audit offline, they could come back to you.
Thank you.
Okay, all right.
And maybe just a suggestion, if there's the board's desire, we could add it to our next year's schedule, if that's going to be okay. Thank you.
Thank you. Going on to item number 17, page 62, 2012-13 following program solicitation initiation. You say it.
Solicitation process.
There you go.
What I'm doing is looking for approval to initiate the basically application process. Given the status of the litigation, we hope when we come back to ask you to initiate this process, we'll have more certainty. When you all approved our last fallowing program, it was a limited program. We only created conserved water for the 2011 calendar year, which means if we have a program next year, we are going to have an extremely large program. So we want to go ahead and get the applications lined up, get the processes lined up. So if we do have the need to initiate that program, we can get started. It's highly likely we'll have to do some additional tweaks to the program in order to get the volume of water we need for next year. We may be looking at early start dates. We may be looking at some different procedures rather than the lottery. It may be sitting out tons of applications and saying whoever gets theirs in first gets first chance at doing that. But we want to go ahead and start that process. And we'll put all the little caveat language we used last time that says subject to board approval, and the details will be worked out later.
So this is an action item for the initiation of the solicitation.
Correct.
The following.
Correct. Solicitation of the following
Got it.
program.
I wasn't going to let it go.
And we're recommending an $85 an acre foot price right now.
You want to up the price to 85.
We've upped it to 85 because we have a tremendous volume need next year, and we're told the ag markets are quite high right now. I don't know that will be sufficient, but I know last time I asked for 85 and it was ratcheted back to 75, and we did quite fine. So our thought is let's try 85 and see how it goes.
Okay, now, Director Mendel, did you
I
make
will
a motion?
move for approval at the $85 level.
Is there a second?
I'll second it with for discussion.
Uh-huh.
Okay. With the rulings getting ready to come out, will these contracts be offered before the ruling?
Let me jump in there. Like everything else connected with the QSA and touched by the litigation, this is purely a contingency.
Okay. I would just make sure as this moves forward, because of the uncertainty, that we have some type of contract exit language and make sure that everyone that's participating understands
I think what we intend to do right now is do like we did last year. We're going to ask for applications, people that are interested or potentially interested, and then hopefully we'll have some decisions on the litigation before we come back to you again saying we want to go ahead and start the application process, or that we don't need to do a program because it's no longer feasible.
Are we at a point where maybe we need to cut it to a half year?
You're at a point from a volume perspective where you may need to increase it to a longer term. We're talking over 150,000 acre feet of water, probably 175,000 acre feet of water.
You know, the advice of your QSA council is to do nothing because it's consistent with what we've done so far, which was put the early mitigation water in the Salton Sea. You know, how do you deal with the uncertainty? I think this is purely to serve as notice to the board that if conditions,
it's a what if.
If there's a reason to go forward, that we already have a solicitation list to draw
It makes sense.
Correct. And we have a waiting list from the last period, but we just want to open it up for all who are interested should we move forward. So.
Okay.
And we did put language in it last time that it's contingent upon the transfer money being there.
Correct. We would not sign any contracts without coming back to you and saying, can we start and how much money do we have to move forward? That's what we did last time.
Can you give it to me one more time, Tina, why it's an increase?
When we contract, these programs start July 1st, so it's 6 months in one calendar year and it's 6 months in the subsequent calendar year. So the way we do the forecasting and come up with our fallowed water requirements, you're pretty much doing half of one calendar year and then half of the next calendar year. So you're mixing programs. Well, in the 12-13 fallowing program, we only contracted for the water for the end of 2011. We didn't get started on 2012. So normally we would have had about 40,000 acre feet of water in the current program.
6 months behind.
Exactly. So it will be, assuming we move forward, it'll be a huge program, and it'll just depend on whether or not the price we offer and the timing works. You're always going to be a little short or a little long, and so always before we've been a little long. It may be that changes when the volume ramps up. But again, we don't know yet. In a way, it's kind of nice that the court hearing is scheduled for November, so hopefully we'll have some better information if we have to come back to you in a higher degree of certainty.
Okay.
I thought maybe you had some insider information on the court case.
You know, I'm not a gambling person, and it's not a bet I would take.
Okay, please vote.
Thank you.
Moving on to item number 18, page 64 on your agenda, major work authorization covering tailwater return system. Mr. Jones, you've been waiting very patiently.
Of course, I
How
have
are
to.
you?
You guys are in charge, so I'm doing fine. We're here to seek your approval for a tailwater recovery system to replace a couple that we had terminated out of the program back in 2009. This is a tailwater recovery systems that's anticipated to generate about 280 acre feet of water on an annual basis. The cost of this TRS is approximately $384,000, I believe, and the cost is totally being paid for out of the Capital Replacement Fund for the Metropolitan IID Capital Replacement Fund. We currently have 24 tailwater recovery systems that we have to maintain. We've lost 2 of those in recent years, and this is going to replace one of those TRSs that we have to replace.
Okay, makes sense to me.
How many acres will this include?
Say again?
How many acres will this cover?
Right now, it's 289 acres totally for the 4 deliveries that are associated with this TRS.
We have a motion and we have a second. Any further discussion?
Yes. Now, this conserved water it's understood, I think it's understood, that it's separate from QSA conservation. Is that correct?
Correct. This is done under the original conservation program Metropolitan and the amended 2007 agreement.
So there's no compounding there in programs, right?
No.
Okay.
We're distinctly different from the San Diego program. We totally have our own verification and procedures for our program.
Yeah, and Alex Jack has always been ahead of his time in water conservation and so forth.
He's one of our outstanding users in terms of
he has
tailwater recovery systems. We have several.
I've seen his
but he's one of them.
operations and very impressed. If there's no further discussion, please vote. Thank you. Moving on to item number 19, page 84, Rio Vista Substation remediation. You're back.
I'm back. Good afternoon, Board. I'm here to request that you authorize conditional approval for an additional $200,000 for this Rio Vista Substation cleanup project. Just to remind you, you approved the major work authorization for $500,000 on August 23rd. As you're aware, this was a fast-paced project as we were required to clean up the contaminated substation site before the school started. It started August 29th. I'm here today to inform you that the project has exceeded the approved major work authorization. The overrun is due to the unanticipated scope changes resulting from additional U.S. Environmental Protection Agency mandates during the substation cleanup. I have specific scope changes. There are 5 of them if you would like to hear a narrative.
I don't.
Okay. Before you, you have a table in your packet, but on the computer screen, you will see that there's an updated table that has more current cost, a better look at the variance. Since we have to submit documents for public disclosure, when I come before you, I'm bringing you a more updated table that shows the cost.
So is $200,000 still going to cover the cost?
Right now, the only outstanding bill is a City of Brawley water bill, and I have tried, and staff has tried diligently to get a hold of that bill or just get estimated cost, but we have not been successful. So
call the city manager. She'll answer your calls.
And that's my next step. But supposedly the bill is in the mail. So, but we just kind of wanted a verbal, but we haven't been able to get that either. But as it stands, based on the numbers, I've still got $65,000 to cover that City of Brawley bill, and it's bill for construction water. So I am confident that that is enough money for that outstanding bill.
So the $200,000 is what you need extra, or is that what you've already expensed?
No, it's on top of the $500,000.
I've expended. Where's my? I have expended $634,729. Well, actually, $25,000 of that is for some remedial action. Sprinkler pipes were broken on school property. Some sidewalk damage was done at City of Brawley property. I did not authorize that until I came before you. That is the only cost that the only activity I really had control over to say, we can stop right here, go to the board as quickly as I could, and expend it if you do approve this. So that $25,000 is counted in the $634,729.
Okay, so the additional EPA requirements, so they're on site and they're telling us to dig deeper?
They are.
Dig wider, dig deeper?
Right, they told us to
Based on their soil samples they're taking, or did they change the scope?
They changed the scopes in many ways, but one of the overruns is because when we did verification sampling, we were required to dig deeper in 12 different areas. And it's not just the actual physical deep digging, it's what do you do with the contaminated soil? It required more trucks, it required more disposal cost.
More fill
To fill it in. Also, EPA required some additional toxicological sampling that wasn't in our scope, but it was something that they required us to do. Also, their presence on site, we had to have air monitoring stations that were part of the construction activity and a public health safety specialist on site. So there were many things that, and it was a rapid project. There were many things that were, just what they were.
It is what it is. We have a motion to approve.
Make a motion to approve.
Is there you going to second it? Second it by Desert.
I've got a
Discussion?
question. Yeah. Now, it's my understanding that we do have an audit in process to see what else we have out there, correct?
Well,
because this was like a 2002 project.
Yeah. And there is a budget history, a budget request history, since we knew about the substation. If you're referring to the hazmat audit report that Mr. Kemp is doing under the regulatory compliance department, that's not going to look at our additional decommissioned substation. But my staff and I are working with Energy Department. We have a meeting this week to discuss some of the other decommissioned substations. We were put on notice by EPA on site that if there's Rio Vista, there's probably more.
Cool.
So, so far I have found 10. Now I'm not asking, and EPA wouldn't require us to clean up all 10 at once. But under self-disclosure, like we did Rio Vista, we will not be assessed fines and penalties. But it does mean we have to provide a schedule. So, first thing we need to do is sample and find out if we do have hot spots on these decommissioned substations. But again, I'm working with Energy. Unfortunately, this is, Rio Vista hit us. We weren't prepared. Next one, and if there are any more, I'm hoping that we will be better prepared and better budgeted for the activity. This was in a school. This was special circumstances. We were going to just work with the state DTSC. However, because of its proximity to the school, EPA got involved and required us to clean it up before school started.
Are we going to put a fence around it again? Because we had talked about not doing that and making a park or giving it to the school or doing something with it, didn't we, board?
The discussions that you have had as a board.
The idea there was to donate that to
Back to
the school and avoid the fence cost if possible.
Yeah, can we avoid the fence cost?
I don't see why we couldn't if the school accepts it. It would make sense.
Well, I mean, you guys are moving forward with it. I'm just afraid you guys are going to put a $40,000 fence
No,
around
we're
it.
we're avoiding that if at all possible.
No, the estimate for the fence was $8,000. I've already done the work for the additional fence to make it back to IID property separate from the school, but that's not part of this estimate because I was informed, and I believe real estate is working with the school to see if they would like the property. The temporary fence that you see up there and the fence expenses were a requirement because we had to actually go outside of our substation site. We had hot spots in the actual playground. So we extended the fence and gave ourselves a buffer. It's a temporary fence. We're just paying rent on the fence. Maybe we could get a little bit of money back when we take that fence down because I believe it's rented for 6 months. And we had to get that was when we were going to do this during spring break.
And that's a good business. $10,000 for renting fence?
Well, there's 2 fences and then there's also the silt screening to keep both the looky-loos out and to keep the dust down.
Well, what are we going to do as a board? Are we going to give it back?
That item is not here for discussion or for approval. It's not, so you're going to have to wait.
I got a question. Vance, I have a question for you. This is cleaned up, and are they going to, EPA going to sign off on this thing, that this thing is clean?
Yes.
Okay, so
I think
that's
it
still
would be important to get that before we think about turning it over to the school, obviously.
What's that?
I think it would be important to get EPA's sign-off.
Well, yeah, that's what I was going to say. If you're going to end up giving it back to the school, because the problem you got kids, and it probably should be fence or something, or talk to the school about it. They're going to take it. They take the responsibility because even though it's been cleaned up, you got kids running around on that ground that used to be contaminated. We don't want to be held liable if some lawyer comes along and says, hey, this kid got sick, and then they go after us. So we want to make sure whatever we do that we're legally signed off.
Absolutely, I agree.
I think being that there was hazardous material there, the thing should be fenced off, at least until we decide what to do with it.
It is fenced off right now, and the principal wants to know, the city of Brawley property, he wants to know when all the fencing, when the site is going to fee made whole. He reminded me of the sprinkler damage. I told him I couldn't go any further until I had additional funds.
Okay, so
But-
you need additional funds, so any further discussion or not, please vote. You got it.
Thank you.
Thank you, Mrs. Bradshaw. Moving on to item number 20, and the last item on your agenda, financial update through July 31st, 2011. Mr. Brokey.
Yes, this
Even
afternoon.
smile? Let me give you the smile again. A wider smile?
That's
There
as
you-
wide as I can
that's
go
a-
right
oh.
now.
Okay, I get what I get.
I just want to discuss the water and energy capital plan this afternoon very briefly. I'm on page 93 of the board package. And as you can see from the original budget, we originally had about $222 million, and as of the end of July, we're projecting to spend about $137 million of 222. That's a little more than 60%. The bulk of that variance is from generation, and almost all of that is El Centro Unit 3 repowering projects that will just shift over to 2012 as opposed to 2011. That money will be spent, but it just won't be spent this year. And then on page 95 on the water department, there are two main drivers of their roughly $22 million variance that we're projecting for the year. One is the water transfer. And here again, similar to the El Centro Unit 3 repowering, a lot of that will just shift over to 2012. And the other category or line item is the electrical upgrades at the Imperial Dam, and those will that $10 million will be pushed out in outer years, probably over the next 3 or 4 years. So we're allowing the other participants in that project to set aside the funds so that we can go forward with the projects. And that's the extent of my presentation this afternoon.
Questions, comments?
Could you go over the water transfer row, Greg, on number 3? On page 95.
What's comprised of those projects?
Yeah, just for
I'll let
example.
Carlos help me out here on that.
Primarily, it's the capital funding for the SCP projects. There's an $18 million fund that's available strictly for capital improvements for the system. Under this,
That's what's that what we're calling the first half of phase 1A? Is that
that's correct. Now the bid package is being reviewed now. It's going to be let sometime early November.
So we haven't expensed any of that $18.5 million?
Only for planning and engineering and management of the contract.
The decision to expense it will be in November.
That's correct. In November, a bid will be let out. Hopefully by December, we have proposals in, and we review those. Those will be the actual proposals for implementation of the SCP projects, including.
Oh, and if the board had some concerns about needing some rainy day money because the QSA is going to fail, and we could maybe pull that back and incorporate that into regular O&M within our water budget
I
to help
believe
facilitate.
this funding is specially conditioned, and I think Greg can address that.
We would not be able to do that, Director Desert. The $50 million that we receive from the Water Authority has to be spent on water system conservation projects.
But there's other conservation projects we could do internally.
If they're water system conservation projects, then they would qualify.
And
yes.
if they qualify for wet water. Yeah.
Is that right, Mr. Kelly? That money's limited specifically, or is it a little bit more flexible than that?
It does have limits on it, and they have mainly to do with system conservation. I suppose you get into the first part of the year, circumstances change, the board could redirect that towards some other form of conservation. The problem would be in San Diego's concurrence with how we spent it.
And if there's measuring devices involved with that first half of Phase 1A, that's $18.5 million, that involve measuring devices that could potentially hurt us or harm us, can you make Mr. DeMars aware of that?
Certainly.
Thank you.
Okay, any other comments or questions from Mr. Brophy? No? Thank you, sir.
Thank you.
Mr.
Need a
Kelly?
motion on that? Do we accept?
No, it's just, you need to accept it?
Acknowledge, okay.
Yes.
Acknowledge, we have a motion to acknowledge the reports.
Acknowledge, move to acknowledge.
Is there a second?
Second.
Please vote. Okay. Mr. Kelly, any further business?
No, ma'am.
We're adjourned.